justice and the impact on the family dynamics. Also, there are some controversial issues which we hope we can be able to have conversations on, especially recent landmark decisions and emerging trends on issues like property rights among cohabitees, distribution of property during separation and divorce, spousal rights vis-a-vis family rights during burial, child justice in post-separation and divorce. I wish to end by thanking everyone for attending this important conversation. For making time to attend at short notice is highly appreciated. I thank the Family High Court Division, JTI, the ADR committee led by the Honorable Deputy Chief Justice for making this event possible. Of course, we thank the Supreme Court for hosting us here in this lovely building. I must confess this is my first time, but it's a lovely building. I cannot thank enough development partners, especially Sweden, IDLO, UNDP, for supporting IAWJ Uganda chapter activities and making this event possible. Special appreciation goes to Barbara, Frida, and Jennifer for always supporting and making our activities successful. This started just like an idea, and now it's a conversation, and it will lead to more conversations. Hopefully, our other development partners will support us on other key aspects that will make family justice a reality to all Ugandans. Thank you for your kind attention. God bless you all, for God and my country.
Thank you very much, President, International Association of Women Judges, Uganda chapter. And thank you for showing us your members and even saying that there are some male members. I have been informed that the most prominent male member is just Batema, but he has not yet arrived. And I can read minds saying, why is there no association of male judges? But I think you can contact the president to have that discussion with her. You are attending the Family Justice Summit just for avoidance of doubt. It is a summit, it's not a conference, it's not a workshop, it's not a seminar. And the theme of our summit is alternative dispute resolution as an enabler to promoting effective and harmonious coexistence in families and communities. That is our theme. And moving ahead to our remarks, we have remarks of the United Nations Development Program resident representative. As you can see, UNDP is one of the sponsors of this summit. But to give us the remarks is the senior economist, United Nations Development Program, is representing the resident representative, and he's by the names Mr. Tangavef Palanivel. Please welcome him.
Good morning to everyone. As the honorable moderator introduced me, my name is Tangavel Palanivel. People call me Palani. I am senior economic advisor, head of the strategy policy team in this office, UNDP in Uganda office. This morning I'm representing, as he said, the resident representative of UNDP, Madam Navani. So my role is very simple. Just I have a statement to read out. Let me start that statement. The Honorable Deputy Chief Justice of Uganda, our invited Chief Guest, Honorable Chief Justice of Kenya, Justice Madam Martha Hong, and Honorable Justice of Supreme Court, Honorable Justice of Court of the Appeal and High Court of Uganda, and Your Worship, Registrars, Magistrates, Her Excellency, Swedish Ambassador to Uganda, and other representative of the development partners, international NGOs, and the representative of the justice, law, and other institutions and partners, and advocate, administrators, and the technical staff of the judiciary of Uganda, colleagues from the United Nations family, especially I recognize my colleague Sharon, the head of the UNODC here. She is sitting next to me. And the distinguished ladies and gentlemen, to everyone, good morning to everyone once again. And it is with profound honor and delight to join you at this important Family Justice Summit. The theme already been highlighted. At the outset, on behalf of the UNDP, I would like to thank the Uganda Judiciary for inviting us, the UNDP, to participate in this high-level strategic event. At the outset, we in the UNDP also appreciate the Judiciary of Uganda, led by the Honorable Chief Justice, Permanent Secretaries, other senior officials, for their visionary leadership and innovative adoption of alternative dispute resolution to enhance access to justice in India, especially to vulnerable people and communities. In simple terms, alternative dispute mechanism, commonly referred as the ADR, is an alternative process to the traditional method of particularly a lengthy, costly court process for resolving conflict dispute. When used appropriately, ADR will bring several benefits. We have actually identified some 7-8 benefits, but to the time, I'm going to highlight only the 4-5 benefits. When used ADR appropriately, it saves a lot of time by allowing resolution in weeks, in months, compared to the court process, which can take years. Second, it saves a lot of money. Third, it puts the parties in control instead of the lawyer and the court. So the parties has their own, involvement, their own say in the decision. Fourth, it focuses on the issue that are important to the people in the dispute instead of just their legal rights and the obligation, etc., etc. It also helps the parties to come up with a flexible, a creative solution on their own terms. So I can go on, highlight the importance, the benefits of this important ADR mechanism. Lordship, distinguished ladies and gentlemen, alternative dispute resolution process is an age-old cultural phenomena in Africa, the entire African countries. In fact, traditionally, African society have resolved dispute through the use of negotiated settlement under the indigenous system of governance. Unfortunately, as the African country became colonized, the government-controlled dispute resolution mechanism like court replaced the old customary traditional law system. In this background, in 1964, the Organization of the African Unity formally adopted the ADR mechanism for dispute resolution at the inter-country level, within the country level, at the community, at the family level. Thanks to such effort, today the ADR become central to the Africa Union conflict resolution effort. There are a number of examples we can highlight how actually the ADR process has been utilized in Sudan in 2005, in Kenya in 2007-8, in 2019 in the Central African Republic to resolve some of those political, other related, conflict-related issues. And even at the community, at the family level, thanks to the proactive efforts of African judiciary, not only Uganda, elsewhere in Africa, and the civil society organization, development partner, in the recent decade, more than half of the actually African citizens, whether Ugandans or elsewhere African citizens, are currently preferring to report their dispute, their problem, to the community leaders rather than going to the police and the court. Lordship, distinguished ladies and gentlemen, we in the UNDP also like to acknowledge Uganda made notable progress in the ADR process in the last decade or so to enhance access to the access to justice to the vulnerable community, women and other people. However, while the ADR can address several constraints, several barriers to justice, its application is not without challenges. Issues of quality, issue of consistency may arise, largely depending upon the skill and the experience of the mediator, arbitrator involved in this mechanism. This underscores the need for mapping out existing mechanism and standardizing the trainings and approaches for its effective application in dispute resolution. Additionally, the regulation, the accreditation of ADR professional is also crucial for effective ADR application. Without proper oversight, concern about professionalization of the mediator, the ethical standard of those providing ADR services could undermine this mechanism. Therefore, establishing a structural mechanism for the mediator, for accreditor is essential. The accredited mediator must also uphold the quality of the justice by thoroughly evaluating the information presented to them, ensuring that the decision promote fairness, do not ensure that some kind of unfairness in delivering the services. Lordship, distinguished ladies and gentlemen, the organizers of this meeting asked the UNDP to particularly to share two questions, answer two issues. One is what is the UNDP perspective on this ADR mechanism globally in Uganda? UNDP views ADR as a vital mechanism for promoting access to justice, especially in the context of where formal judicial system may also be overburdened, inaccessible to the vulnerable community people like women and all. In this context, in several countries across the world, in Africa, Asia, Latin America, other part of the world, UNDP currently have ADR project to increase access to justice for the most marginalized population group, predominantly women, other excluded groups. These projects intend to enhance the alternative dispute resolution practices already taking part in that country, in their community level. Our approach to the UNDP approach to the ADR is a holistic, recognizing it's not only means for improving access to justice, but also as a powerful tool for fostering accountable governance, peace, building resilience, and inclusive society. Especially UNDP perspective on ADR emphasizes several key aspects. It enhances ADR, enhance access to justice for vulnerable people. It also save time and cost. It also have relevant to the traditional culture, the community level engagement to reduce some of stress and other things. It also, the ADR also promotes social harmony. It also support the complement the formal legal system. It's not a replacing, rather it's add, complement the existing overburden, the court system. It also uphold the human rights, fairness, and other related things. And finally, it also enhance the sustainable development, stimulate local economic development, because it improves the access to justice, which is crucial for achieving the sustainable development goals. Lordship, distinguished ladies and gentlemen, now let me turn into the second question which UNDP was asked to do that. How UNDP partnership, collaboration with the judiciary in promoting access to justice and the rules of law. I am pleased to mention that UNDP has been and continues to be active in supporting the legal reforms, policies, practices instituted by the judiciary and justice actor in Uganda and the rest of the world. As I indicated earlier, UNDP has been supporting a number of projects across the world in several countries in supporting this ADR process with a special focus on two areas. Like across our project in the world, it tend to focus two areas. The first area is that the enhanced use of quality of the arbitration process, the mediation through the strengthening the relevant institution and providing capacity to the relevant people involved. The second is the capacity, enhancing capacity and the qualification of the mediator, arbitrator, legal professional, judiciary to promote consistent, efficient, fast resolution of commercial dispute, other dispute. In Uganda, we are dedicated to advance the judiciary effort under the administration of the Justice Program, the National Development Plan number 3, and the furthering Uganda progress towards SDG 16, which is the promoting peace, justice, stronger institution. In this regard, beyond contributing to the rollout of the ADR mechanism alone, UNDP provide a comprehensive set of support, technical assistance, a number of access to the justice area. Let me highlight few of them. Establishing a video conferencing system for court, prison, in number of court and prison in Mubende, Jinja, Masaka, Bale, Gulu, Mukono, which is all actually been established, are in the pipeline to establish video conferencing in these cities. Installation of real-time transcription of the equipment in 8 courts to improve the efficiency, accessibility, and the participation in the court process. It's basically a digital transcription equipment. Number 3, digitalizing the Judicial Training Institute to enhance the learning and development. Number 4, setting up a toll-free line call center to improve access to justice for the marginalized, ensuring no one left behind. Then also organizing the court open days, media engagement to strengthen the link between judiciary and the common citizen. Capacity development training of judiciary officers on topics such as the law reporting, case summary writing, customer care, etc. Then developing rules and guidelines for the electoral dispute resolution. Then we also, UNDP also supporting integrating gender equality into the justice system through gender equality and Silapurus, etc., etc. Ladies and gentlemen, to conclude, on behalf of the UNDP, I reiterate UNDP commitment to support the judiciary system in Uganda to promote the ADR process, other legal system to enhance access to justice, other aspect related to the law and legal system. I am confident that this summit, through the exchange of knowledge and idea, can significantly influence the use of alternative dispute resolution process in enhancing access to justice to vulnerable population group, vulnerable community in this beautiful country. I thank our partner, the Judiciary of Uganda. I also thank our collaborator, International Developmental Law Organization, for organizing this 2 days summit on the family justice system. I wish you all a fruitful deliberation in the next 2 days. Thank you very much for this opportunity.
Thank you very much, Mr. Palanivel, representative of the resident representative. Let's give him another round of applause. I think you sat for too long, so let's stand up a bit. And while you're standing, we are going to welcome the Swedish Ambassador to Uganda, Her Excellency Maria Håkansson. Welcome, Your Excellency. Let's give her a round of applause. She's the one who will ask you to sit down if she wishes.
Wow. Let's see how I will use that power, but now please, of course, sit down. Honorable Deputy Chief Justice, Honorable Justice Mike Chibita, judges of all levels of courts, of courts, heads of diplomatic missions, UN family, especially UNDP here represented, IDLO, our partner, and the Vice President of Uganda Law Society. Distinguished ladies and gentlemen, allow me to stand on the protocol already established. It's a great honor for me to make remarks today at the Family Justice Summit. Sweden is a long-term partner of Uganda, and as many of you will know, strengthening rule of law, human rights, and democracy are priority for our development cooperation strategy here in Uganda. Over the years, the Embassy of Sweden have provided financial support towards these priorities through several partners, including the International Development Law Organization, IDLO, UN Women, UNFPA, UNDP, the Hague Institute for Innovation in Law, just to mention a few. And today we are very delighted to be part of this summit that's been organized jointly with our partner IDLO, currently implementing a program to enhance the accessibility, quality, and sustainability of justice services for citizens in Uganda with support from Sweden. This year's, the 2024 Hague Institute for Innovation in Law Justice, their Justice Needs and Satisfaction survey revealed that among the major justice problems that people encounter in Uganda, you will find both land and family issues considered to be the most serious problem when it comes to their legal categories. I think this was also confirmed by the remarks by the Vice President of Uganda Law Society, but this survey also revealed that Ugandans are highly motivated to resolve their most serious legal problems, and including through mediation. Rule of law can only be measured against the citizen's right to access justice. It's therefore a constitutional priority and objective for any state to continuously secure and improve the quality and accessibility of justice services delivered to the people. I therefore believe that the timing of the Family Justice Summit that seeks to explore the use of alternative dispute resolution in family matters before the courts is both timely and relevant, as it seeks to respond to the needs of the people as expressed in this survey. So let me commend the government for championing the use of alternative dispute resolution, and for the judiciary, of course, to enhance access to justice, evident through the Cabinet's development of the alternative dispute resolution policy, but also the Ugandan judiciary's alternative justice system strategy from last year. The government of Sweden believes that the alternative dispute resolution processes, when correctly utilized, can be both efficient, cost-effective for resolving disputes, but also preserving relationships and confidence levels from the people it's there to serve. This summit provides an opportunity for the judiciary to explore the use of alternative dispute resolution in family-related matters before the courts, and allow me to restate Sweden's commitment to strengthening the rule of law and promoting respect for human rights and democracy in Uganda and globally. I sincerely thank you for inviting me and for listening to me, and I wish you fruitful deliberations during this 2-day summit. Thank you very much.
Thank you very much, Your Excellency, the Ambassador of Sweden to Uganda. We're now heading to the official opening of the family justice system. And please, let's rise up and welcome the Honorable, the Deputy Chief Justice, Honorable Justice Richard Butera, who is going to give the official opening, and let's give him a rousing welcome.
Kindly take your seats. I was instructed by the Chief Registrar to adopt the protocol, and I hereby comply. I warmly welcome you to this Family Justice Summit that has been organized by the judiciary in conjunction with the International Law Organization, ILO. The theme for this summit is Alternative Justice Resolution as an enabler to promoting efficient and harmonious coexistence in society. The judiciary has adopted the use of ADR as one of the strategies for case management. We had a case management settlement last week, 5th to 9th August 2024. The case management week has been piloted at the Court of Appeal, the Family, Land, Civil, Commercial Divisions, and at the circuits of Mukono, Masaka, and Guru, plus the Chief Magistrates Courts of Mengo and Makindye. 200 cases were disposed of during that week. The Family Division successfully concluded 27 cases. At the Court of Appeal, we concluded 41 cases. Ordinarily, these cases would have taken us months of hearing the cases and writing the judgments. It is clear from the results of last week that alternative justice resolution mechanisms lead to faster conclusion of cases. The process is faster and it is cheaper. There are no appeals, and that reduces backlog both in the lower courts and the appellate courts. The Case Management Committee, which I'm privileged to chair, shall study the outcomes of what was done last week and plan for the future. Mr. Vice President, Uganda Law Society, we shall discuss the training of lawyers, and that will help us progress. We shall develop rules for the appellate mediation and amend rules, the 2013 mediation rules, as shall be found appropriate by the Law Reform Committee chaired by the Principal Judge. Alternative dispute resolution mechanisms include mediation, arbitration, conciliation, and negotiation. These methods may be engaged independently or in conjunction with each other on a case-by-case basis. Alternative dispute resolution is well grounded in our Constitution and in our civil procedure rules. The 1995 Constitution enjoins the judiciary to promote reconciliation between the parties. Article 126 provides, sub-article 2, as follows. In adjudicating cases of both a civil and criminal nature, the courts shall, subject to the law, apply the following principles, and D says reconciliation between parties shall be promoted. Order 12 of our civil procedure rules provides 1. Scheduling conference. The court shall hold a scheduling conference to sort out points of agreement and disagreement, the possibility of mediation, arbitration, or any other form of settlement. This being a family summit, the aspect of the family needs should be put into perspective. The family is a basic unit upon which our society is built. Principle 19 of our national objectives and directive principles of the state policy in our Constitution states, the family is the natural and basic unit of society and is entitled to protection by society and the state. A society can prosper or decline depending on the quality of families upon which it is built. It is important to nurture and maintain strong, united, and progressive families. Such families create a foundation for socio-economic transformation. Some families remain vulnerable to being sources of conflict amongst their own members in the community. Family conflicts range from succession disagreements, marital conflicts between spouses, custody of children, maintenance and support, cultural and religious differences, to mention but a few. When such conflicts arise, they usually carry emotional undertones, which, if not well managed, can lead to devastating effects to those involved directly or indirectly. ADR becomes relevant in building cohesion and restoration in families with conflicts, and it helps mitigate the damages caused by disputes in these families. ADR should be embraced in settling family disputes. There is need in a family dispute for confidentiality. There is need for expeditious disposal of such matters, especially those involving children. Children grow and move on. Family conflicts should therefore not take long to resolve. Otherwise, the disputes may lead to conflict, and that might even be tragic. Rule 18, Sub-Rule 1 of our Judicature Mediation Rules 2013 provides, the mediator and the parties to mediation shall treat as confidential information obtained from or about parties in mediation, and shall not disclose that information unless required by law to disclose, or the parties give consent in writing to the mediator to disclose. Unlike litigation, whose processes attract public attention, the press, and sometimes publications of the result of a dispute, alternative dispute resolution is confidential in nature, and this helps protect family members from the effects of family disputes. This element of confidentiality reduces societal pressures and stigmatization associated with litigation. ADR promotes harmonious coexistence even after conclusion of a dispute. ADR is therefore relevant in family justice since the parties discuss and agree on the terms of settlement. The parties agree on a win-win position, which reduces the possibilities of animosity and adversariety. The judiciary has a policy of re-engineering and promoting ADR. We have now 83 court-accredited mediators who are commissioned by the Chief Justice. Most of them have been involved in concluding the work of last week. They will continue to conduct mediations in the pilot courts, including the family division of the High Court. Let's all support them in this peaceful and cost-effective settlement of the disputes in our courts. I have looked at the topics to be discussed during this Family Justice Summit. They include family justice landscape in Uganda's administration of justice, alternative dispute resolution and alternative justice systems as family cohesion tool in the resolution of criminal justice, estate planning in Uganda, adopting ADR as a best practice in management of estates, overview of mediation practice and tenets of mediation, and packaging the STAR approach when mediating family matters, among others. I'm confident that at the end of this summit, we shall all have gained more insight on how alternative dispute resolution can enable us to move and promote effective and harmonious coexistence in our society. I'd like to thank all our development partners for enabling this.
Director, Ms. Barbara Kiley. Ms. Barbara, you're very most welcome, and we do recognize you fully. She did not come alone. She came with Mr. Samson Asimwe, also from IDLO. You're very most welcome. And also Ms. Jennifer Acholoi from IDLO. Thank you so much, Team IDLO. We also have UNODC we have the head of office, Miss Sharon Lesa Nyambe. You're very seeing them as we go along. We will have group photographs, and I'm going to guide us on the order. And after that, we are going to have tea. Now, break tea is being served in 2 places. The first point is at this level, level 7, just there for people who are familiar. And like the President, International Association of Women Judges, people who are getting here for the first time, you will be ably guided that we can have tea at this level. And those who will have tea here is the high table and all the justices and judges, both serving and retired, together with development partners. The rest of us, we are going to level 6. That is just 1 level below. So feel free to use the staircase. There is a wide staircase just on that side. Our protocol officers, be quick in leading our guests so that 30 minutes we take tea, and at the top of the hour 11, we are all back here. So we are going to have exactly 5 photographs, and we are going to move quickly. So the first will be the high table, and we are going to have 10 seats down so that we are all able to fit. And the first photo, the high table, will be joined by the justices and judges, all of them who are here. Please, you will come for this photograph. The second will be all the court accredited mediators. I see very many of them. You will be in the second photograph. The third photograph will be the high table, which is a constant, with all their worships, the registrars, the magistrates, the senior administrators, the law society will be here, other than those who are not the representative of the president is going to be seated, but the rest who will not be sitting, you join this photograph. The fourth one is a photograph of the high table and all the members of the International Association of Women Judges. My Lord, we have the male representative here. After Justice Batema, we always talk about Justice Mugabo. He's one of those old and long-serving members of the association. And then the last will be the high table and the invited guests who may not appear in any of the categories that I have said. So the high table is the Honorable, the Deputy Chief Justice, the Acting Principal Judge, the Chair of our session. We have Her Excellency, the Swedish Ambassador, President, Law Society, the Vice, please, you will take a seat. The President of the International Association of Women Judges, Uganda chapter, you will take a seat. The representative of the resident representative of UNDP, you will also take a seat. And the Chief Registrar will take a seat. So those will be the constant on the seat. And then the first category, my Lord, justices and judges, serving and retired. Please begin to make your way forward. After they are done, category 2 will be the court accredited mediators. Protocol, lead the high table, please, and guide accordingly. Daniela and team. Worship Timothy, please come and assist. DCJ, PJ, Chair Governing Council, Her Excellency, the Ambassador, Vice President, Law Society, President, the National Association of Women Judges, UNDP, and the Chief Registrar. Your Worship Timothy, you could come here as well for further instructions.
My lords, let's have category 2, the court accredited mediators. Some of you, my lords, will remain behind. All the mediators, please come and join in. Yes. So some of you are getting a bonus picture. Daniel, if there are many, we could probably have 2. There is space the other side, on my right. Worshipper Yetis. Oh, sorry. Thank you. Let's have the registrars, magistrates, and the senior managers. All registrars, all magistrates present of all categories, and then senior managers. And advocates. Advocates, please also join in. Council Isaac and your team. Long time. Thank you so much, my lords and your worships. Next, development partners. Development partners. All development partners. Thank you so much. Lastly, all invited guests, if you fall in that category. All invited guests. Council Fiona Wall, I think you're in that category. All invited guests. Council Francis Jimara, I didn't see you come. Okay, you're mediators. Okay. Thank you, Administrator General. Thank you, Doctor. Thank you so much, my lords. We can now proceed for tea. Level 6. We have only 30 minutes, my lords and your worships, so let's try to keep time.
My lords and all of us, please, protocol officers, let's not begin the conversations. Please direct the participants to take tea, and let's have everybody back here. 5 minutes to 11, the session chair is here, the presenters are here. Let us manage time.
I don't have any security at home.
I request us to come in, and protocol team, please go out and bring their lordships and the participants. The session chair has already taken her seat. Today we are managing this summit English time, not Ugandan time. So when you delay, you find the session has started. So as soon as the Honorable DCJ comes in, we will start with those who are here. So protocol, let's have members come in so that we are able to all take off at the same time. So the Honorable DCJ is walking in. I request us who are standing to please take our seats so that we can proceed. My Lord DCJ, you're most welcome from the break tea. Acting PJ, you're welcome. So we are set, and we have our session chair, who is the Honorable Lady Justice Monica Kalyejira Mugenyi, Justice of the Supreme Court. I now hand over to her to run us through this session. My Lord, you're welcome.
Thank you, Your Worship. Can I please have the panel discussants please come up? Justice Keitirima and Lady Justice Nagawa. My Lord, the Deputy Chief Justice, my Lord, the Acting Principal Judge, my Lords, Your Worships, distinguished participants, ladies and gentlemen, I shall stand on the protocol that has been established so we can save time. Our topic for discussion this morning, Our topic for discussion this morning is the family justice landscape in Uganda's administration of justice, situation of family justice in Uganda. For those of us that have practiced or served as judges, we shall find that there is a strong connection between family justice, crime, and land disputes. It's perhaps time, therefore, to consider innovative ways to solve these disputes in that area of the law. We have 3 able participants that are going to participate in our panel discussion. I'm not sure Mrs. Ndiko is around. Fine. So they need no introduction. To my left is Justice Keitirima, the head of the Family Division, and to my right is Lady Justice Celia Nagawa, the focal judge on children justice in the Family Division. And our third participant is Mrs. Innocent Ndiko, a practitioner in family law of long standing, really. We shall have another presenter, Dr. Patricia Atim, an ideal or consultant later, but we shall start off with a panel discussion. So, Justice Keitirima, you have 10 minutes. Please present on the other side. Thank you.
Thank you very much, my Lord Chair, my Lord Deputy Chief Justice. I think I will stand on the protocol as already laid out, only to say that we in the Family Division are very excited by this summit because of the prominence it's giving to family justice. So as you know, a family is the fundamental and basic unit of society. Strong families build strong communities, which in turn build a strong nation. Objective 19 of the National Objectives and Directive Principles of State Policy, as provided in the Constitution, provides that the family is the natural and basic unit of society and is entitled to protection by society and the state. A family therefore plays a crucial role in society by ensuring the safe development of children, forming healthy generations, and maintaining social cohesion. In the Hill Report, Justice, Needs and Satisfaction in Uganda 2024, it was found that family-related problems were second to land as the most serious legal problems people encounter and report on. I am sure that even with land-related problems, they arise because of misunderstandings in the family. This arises, for example, when administrators of estates sell land without the consent of the beneficiaries, or when the beneficiaries sell land without the consent of the administrators, or even when a wife or husband sell family land without the consent of their spouse, mortgaging land without spousal consent. So as you can see, even with the land-related disputes, they arise quite often because of the disputes in the family. Now, I'll give an example of the category of cases we handle in the land division, and I think that image is what prevails in the entire country. The statistics as they are laid out, and you can see that the majority of the disputes actually are inheritance-related disputes. Many people believe that our major role in the family division is just to separate husbands and wives. That's not the case, as you can see from the statistics. The majority of the cases are actually inheritance-related cases. The nature of our cases are very emotional and therefore protracted. On average, it may take 2 years or more to resolve each case. It's therefore very costly, time-consuming, and by the end of that time, there's no family to talk about, as there's simply acrimony between the family members by the time the case is determined. Beneficiaries who are still school-going may fail to attend due to lack of school fees, even when the deceased has left enough to share amongst the beneficiaries. It's usually survival for the fittest, and the rule of the jungle usually applies. The powerful in the family therefore take the largest share to the detriment of the weaker beneficiaries. And therefore, since the nature of the cases are very sentimental, a party who is dissatisfied will usually appeal. It's therefore not surprising to find that a family-related problem may take up to 5 years or even more to resolve when the appellate process is exhausted. A simple dispute in a family could take 5 or more years to resolve. The issue now, therefore, is even when these people get a judgment in the Supreme Court, would we have resolved the dispute? Or would we have just declared a winner and a loser? Where does that leave the family? You know, the type of clients we have in our courts are closely related. A father and a wife, a husband and a wife, children and their parents, aunties, uncles. So when we make a judgment, we are actually telling this child that you have lost before your mother, or we are telling the mother that you have lost before your child. So would we have resolved actually the dispute? Would we have left the family as intact as we are supposed to leave it? Would we have created cohesion in the family? It's therefore imperative to rethink our dispute resolution mechanism, especially when it comes to family-related disputes. We should, as much as possible, ensure that we maintain the harmony in the family. Whether we like it or not, a family has a permanent bond, either by blood or by relation. Even for people who have divorced, if you've left behind children, there's a permanent bond that will keep you together. When these children are graduating from schools, inevitably we will attend the graduation together. When they fall sick, you may find yourselves in the hospital together. When they are getting married, inevitably you'll find yourselves together. So there is a permanent bond, whether you like it or not. And that's why we think family justice must be given priority if we are to ensure cohesion in our families and even society. Now, our role as a division is to ensure the smooth transition of wealth from the deceased person to the beneficiaries, or to ensure that when the spouses have reached a point of divorce, we ensure a dignified exit. In this country, there are programs like wealth creation. But for us, we're actually dealing with wealth that's already there. And our job is to ensure a smooth transition of owning this wealth to the person who has passed on and to the ones who are seeking for it. And those are the disputes we usually handle. Now, I want to give an experience from the settlement week which I participated in. We had about 7 mediators who actively participated in that settlement week. And my Lord DCG, actually, it was not only 27, but it was 34 cases that were resolved in that settlement week. I must say that in my tenure as a judicial officer, that was the most fulfilling week I had. Because I was able to settle 9 disputes. If I were to write judgments in those 9 disputes, I can assure you it would have taken more than a year. And for once, I saw parties thanking me as a judicial officer. Both, very rare in our court setting. And of course, I was guaranteed that there was no argument of my decision being appealed against, because everybody was comfortable. Very refreshing, very fulfilling, I must say. Parties were all satisfied and actively participated in the resolution of their conflict. The outcome was satisfactory to all the parties. It took less time and cost in resolving these disputes. Some of these cases had been fixed in October, November, you can imagine. It increased the output of the court. There was active participation by everybody, by members of the bar, who also participated in resolving these conflicts as mediators, and others who assisted the parties to reach an amicable settlement. And that talks about the attitude. The advocates who came with that positive attitude to assist their clients to settle are the ones who actually settled matters. I had an experience of one who came to me and said, "My Lord, we are not here for a conversation. We filed a case to be determined, and we think we have no room." And I said, let's give it a try. We gave it a try. And before you knew it, in less than 1 hour, we had settled the dispute. Now, these are the challenges which I think we should address ourselves to. There is limited space in the courts for accredited mediators. Some therefore had to work for a few days to create space for the others. The issue of infrastructure, my Lord DCJ, I think is very pertinent. In the short term, we could maybe hire a structure. There are so many buildings in this town which are empty. I am sure if we negotiated well, we would have a good deal. But let's create space for our accredited mediators if they are going to work to maximum capacity. The other challenge was, of course, the attitude of some key players who frustrated the mediations. Those that never worked out, you could see it was about attitude. Somebody tells you, I think if we go for litigation, we shall get a better deal. And it's both the patients. The other challenge was absence of some parties or their counsel. Being stuck in the adversarial system of resolving disputes, you get instances where people say, I have a preliminary objection to raise in a mediation. And you say, wait a minute. This is about a discussion. It's about interests. It's not about rights strictly. And of course, it requires a lot of patience on the part of the mediator, especially if that mediator has been a judge or a judicial officer that is used to giving orders and judgments. You require a lot of patience in managing this discussion. So what do I think is the way forward? I've already stated the need for space for our mediators if we are to utilize them to maximum capacity, provision of the financial resources to facilitate the process, and on this note, I would want to thank our funders, IDLO, UNDP. Continue supporting. This is a very noble cause. Continue supporting. Don't tire. As Oliver Twist said, we still want more. And of course, with the judiciary of Uganda, surely we should invest wisely. And this is the area to invest. Training of all stakeholders, especially judicial officers and lawyers. It's equally important to educate the public on what to do, especially to minimize family-related disputes. And one practice I would encourage most of us to do, including the lawyers, is to encourage your clients to write wills. If everybody could write a will, I am sure the disputes in the family division will reduce by a half. That's what I want to believe. But if I was to take a quick census even in this room, I would be shocked. It's not also about writing wills, it's how to write wills. The common mistake I've seen when people write wills, for example, is naming executors whom they have not consulted. You could be having a friend, and you think once you pass on, you'll be the rightful executor. But your friend is your friend at the point of death. I could be relating with the head of the family when I know that the rest of the family members are very problematic. And I may not want to take on that responsibility. So please, for those who want to write their wills, consult your executor and say, is this a role you're actually willing to take on? Also, I think we should now start, as they do in contracts, write a resolution mechanism clause. Put there a resolution mechanism clause. Before my family members can go to court if a dispute arises, I would wish that they first go to so and so. You can name mediators in your will to say you can go to so and so before you take your dispute to court. How do we prepare administrators of estates? Administrators just fall in two things. And there's a challenge on how to manage thereafter. How do they make inventories? How do they make final accounts? You're an administrator and you have a mathematical formula to apply as provided for in the law. How do you distribute this estate, even when you are guided? It's like giving somebody a cow, or giving 10 people a cow, and you say, you share this cow. Before you know it, some people will be fighting for ribs, others will be fighting for the head, others will be fighting for hooves. So there is that challenge. I want also to propose that this country should invest in family schools to prepare our children when they are entering into marriages. People just meet each other day one, day two, admire each other, and they enter into a marriage. They are not prepared for what they are entering into. Really, I think, especially in this age and era, we should find time to prepare our children before they join this important institution. Even when they meet challenges, there should be an institution these people go to. I know the churches play their role, but I think as a state, in my view, we should prepare people on what to expect in a marriage. I'll give an example. It's common practice that in a family, the man will say, my money is for investments and your money is to just buy food. Common practice. It reaches a divorce and you're about to share property. The common question that is asked is, let her demonstrate her contribution and I'm willing to refund.
My Lord, I didn't want to interrupt, but I think
I'm
you
about
need
to
to
conclude. So that's why we need to prepare our children. When you're entering into a marriage, it's not about love. It's about preparing even for the exit, if the inevitable happens. Succession planning, for example. In conclusion, because I want to respect my chair, I want to believe that most of the disputes in the family division can be settled by way of mediation. This the initiative that we support. That's an important initiative, and we pray that the momentum that has been built, especially in the settlement week, should be maintained, as we believe that mediation is the best conflict resolution method in family-related disputes. I want to thank you for listening to me.
Thank you, my Lord Justice Keitirima. We shall have Lady Justice Nagawa.
Good morning, my Lord DCJ. All protocol observed. I am standing here today to present to you a child case in the family division. I'll start by talking about families that we've all heard about. And my definition is quite different, just a social aspect of it. Families can be scenes of some of the greatest joys, as well as the greatest sadness that life can bring. Studies suggest that a substantial majority of people, families are more important to them than jobs or status. The incorporation of law into family, therefore, gives rise to questions of enormous importance to the individuals who appear before courts and society at large. The importance of families to individuals is emphasized to the extent that human beings are social animals. They depend on others. Their family or extended family is a group on which people most heavily depend socially, emotionally, and often financially. There comes a point at which, for some prolonged and unavoidable separation of this group, seriously inhibits their ability to live full and fulfilling lives. Children, as has been discussed earlier, children are the most vulnerable members of the family unit, and divorce has led to a generation of children who feel isolated and have antisocial behavior. The family code has an enormous responsibility and privilege of ensuring that the rights and welfare of a child are upheld by providing a legal framework within their safety, health, and development that can be protected. The task at hand at the family law court, for the family law court judges, advocates, and the like, is of utmost importance, as stated by Jackson L.J. in LL versus Lord Chancellor. Family court judges undertake some of the most odious and emotionally draining cases that come before courts. Their task can be a lonely one. Feelings run high in family cases. People who are otherwise entirely reasonable may become aggressive or obstructive litigants when contesting the future arrangements of their children. As family courts, we play a pivotal role in protecting children's rights, and we must explore necessary steps to create a nurturing and just environment for every child through a comprehensive understanding of the elements that affect children in contact with the law. We become better appreciative of the significance of family justice and commit ourselves to fostering a society where every child can thrive. We have two major problems at the division, and that is delay and the adversarial nature of proceedings. When we delay these cases, it affects, if it's 2 months delay for a young child, it represents 1% of the whole childhood. And this delay is emotionally draining for all involved, and we should try to do away with it at all costs. The second, which I've already spoken about, the nature of the proceedings. For example, in most divorce cases, which are not a direct result of physical abuse or any serious crime, but rather conflicts that arise out of two people growing apart, which results into marital conflict. It leads to divorcing couples arguing deeply and emotional issues that come up in the courtroom, which might have been resolved quickly, simply outside court. Unfortunately, these are the environments that are most stressful to children, because children value love, support, attention received from both parents. And when judges do hand down judgments, particularly decisions that determine how separated parents share responsibility for their children, compliance is low and enforcement is ineffective. So what are the key principles that court could consider in the approach of the family justice system on behalf of children? As you may be aware, the welfare of the child remains a paramount consideration in any proceedings determining the upbringing of a child, and the family unit is always the best place for bringing up children who may mean well in a society and the future of the nation. And except where there is risk of significant harm, this should be the primary consideration. And ideally, problems should be solved out of court, and the courts will only become involved where it is necessary or where the parents are unable to make decisions that contribute to the child's well-being. And where possible or admissible, children of age must be allowed to make their voices heard on issues that affect them. Cases that need court hearings, where mediation and arbitration fails, should be taken through quickened hearings. So they are disposed of quickly, as they affect the prolonged hearings trickled down to the children one way or another, especially where parents resent each other. and this affects them negatively. And as the courts should only be allowed to step in when a family has reached a severe breakdown, where conflict is high and the resolution through mutual agreement seems unlikely. To us as courts, we aim to be fair, and in the process, we are impersonal, and we don't normally resolve issues on the face value of it, but we go deeper to that, and that could have a different result to the child. How to make a difference for the children? How do we, as the court, make a difference for the children who find themselves before us, be it custody disputes, adoption, guardianship, or succession? We should try to make child-centered decision-making processes. Children come to court for several reasons, like their parents having failed in identifying them through their last testaments as their biological children, their parents having abandoned them, or they have unfortunately become orphaned at a tender age. There are also cases where children are seeking protection in unfair succession disputes, or children looking to court for protection of their assets and interests in property. We should ensure that all decisions are made in their best interest at the forefront. And in applications where we have guardianships, for example, in interest of property, we should ascertain their wishes as far as possible. In cases where parents seek to sell the child's property, and that parent should have to come to court and prove that there are no other ways that they can raise the funds to look after this child, and that indeed these resources are going towards the child. Also, we should encourage, and this has been spoken about since we entered this room, we should encourage and facilitate ADR. Unlike traditional litigation, ADR methods such as mediation and arbitration provide a less adversarial and more cooperative environment, allowing parties to communicate openly in a safe place and work towards mutually agreeable solutions. Also, embracing ADR methods, specifically mediation, and why mediation is better for children who are subject to legal battles. Divorce can be a traumatic experience for children, shaking the foundations of their emotional and psychological well-being. And during this entire process, separating parents can significantly influence how children cope with this challenge. And therefore, mediation is better. And why is it better? It minimizes conflict and emotional stress on the child. It encourages parental cooperation between parents. It preserves family relationships. It gives children a voice. It fosters long-term well-being of a child and expedites the case processing. And finally, it allows support services and fosters a compassionate environment. And as I conclude, the shocking condition of the court estate today reflects decades of neglect, underspending, and penny-pinching cost-cutting. The truth, though, is that there is inadequate recognition, both in vital importance of the rule of law and of the equal vital need to ensure the justice system properly funded and resourced. Without the rule of law and without a properly resourced justice system, there can be no democracy, no fair and stable civil society, and indeed, no thriving economy. The rule of law and its essential concomitant, a properly resourced justice system is not some optional extra, a truth. The first two responsibilities of any government must be defense, protection from external enemies, and a justice system adequately resourced to maintain and enhance the rule of law. It is generally accepted that the state has the responsibility to ensure that there is a fair and effective means of resolving family legal disputes. The question is how the state meets the responsibility. The issue facing family law currently is whether mediation or self-represented legal proceedings are adequate. It is generally accepted in principle that the resolution of family disputes has a profound impact upon society more generally, and they cannot be categorized as simply private squabbles. Thank you very much.
Thank you very much, Lady Justice Nagawa, and thanks for keeping time. I shall ask my sister, Mrs. Ndiko, to do the same, 10 minutes.
Good morning to all of us. All protocol observed. I'm going to present my paper using the lenses of an advocate as regards mediation in the courts. So I want to give you that perspective, what we advocates get from mediation. I've seen mediation in the family division. It began with the mediators from the Pepperdine University in the USA many years ago, and it has done a good job in the family division of the High Court. Right now, the court has trained mediators, and they have helped a lot to decrease on the backlog. Family division is a very emotional court, so it's therefore important that mediation is done in that court. Personally, I filed so many cases in that division. However, in a year from my own law firm, I have 3 to 5 judgments because I prefer to solve my matters in mediation. Rarely do I get a judgment because I have embraced mediation. And I'll give you reasons why mediation is good. One of them is confidentiality. It has been talked about, and the mediators tell the parties whatever you say in mediation will not be used against you in a trial. And this has helped to build the confidence of the parties. They are free to express themselves in mediation, and this has had a very good impact in mediation. However, there are some litigants who come to trial and they think they should record. Like last week, I saw a party recording, and the mediator asked him not to record the proceedings. Then, as already mentioned earlier, mediation gives self-determination. The parties are able to give solutions to their problems than having the courts force down solutions down their throats. If that happens, this is a family unit, and there will be further divisions, but better let the parties find their solutions so that they can live on happily even after the court process. Then mediation is informal, and I like the way how some mediators handle it. Some mediators, which I kindly request they do, let the parties sit at the front, not the lawyers, because you're addressing parties. But some lawyers want to sit in front and the parties behind, yet mediation is for parties. So this informality, they let it be as informal as possible. And recently I saw one last week. I told the mediator, can we sit behind as the lawyers? The lawyer said, no, these are our seats. And he forced himself to the front. So I kindly request the mediators, make it as informal as possible. Then, as already said earlier, mediation helps on decreasing of cases. Yes, there's people are asking for more judges. And if you bring more judges, we shall still have more courts because of the growing population, and people are aware of their rights. So they'll still file cases in court, and you still have a lot of backlog. So it's my request that we embrace mediation. We shall save more time
in litigation than going for hearings. In Kenya, mediation has been embraced very well and is helping them to solve cases. They have so many mediation registries that has been set up in Kenya. Then mediation is not appealable, which is a very good thing. So this decreases the cases in the appellate courts. Then it's cost effective because it is free and is a much faster way of getting a remedy. No, not much money is paid. Like personally, when I'm billing in my cases, I tell my parties, if the case is to be had through mediation, you'll pay this. If it's to be if a full trial, the fees will be this. So the clients pay less money because the matters are disposed of much faster. As already said earlier, it preserves relationships between the parties because they are mainly families. So if they mediate and they give their solutions to their problems, their relationships are preserved. However, I have noted challenges in mediation. And my worship, Justice John Ketem already said this, there is no space in the family registry. So it is my humble request that the judiciary finds a place where this mediation should take place on a daily basis. I know the mediators in the family division work 1 day a week because they have to create space for others. So it's important that it continues than just having it one person working 1 day a week. Then I want to talk about this 1 week mediation, which happened last week. It was a very good one. And personally, I think I resolved one case. There is one which I think we shall resolve. Madam Betty Kisa, we shall report back to you. You asked us to go for a mediation lunch. We are having the lunch today. And I believe we shall come back and give you a good report after our mediation. Then, then I would like to, another shortcoming I'm seeing in the mediation is that some mediators don't take charge of their mediation rooms. The lawyers bully the mediators and the lawyers take charge. So I kindly request that the mediators are in charge of their mediation rooms. Some lawyers have no or little respect for mediators. This morning I talked to some lawyer that I'm going for mediation, I'm going to address judges. What problem do you see? Tell me, last week I went for mediation and they gave me this young mediator. How can they give me a young girl to mediate my case? Then I asked her if the judge had been young, wouldn't you go? She told me, yeah, but they should give us senior mediators. So lawyers have a bad attitude. Because someone is young, I can't appear before her. So even if you are young, kindly take charge of your mediation room. Then the mediators the lawyers love legalizing the proceedings, which is not a good thing. Everything is about the law. They feel they are in charge and it jeopardizes the proceedings. Then I also wish to bring it to your attention that some mediators ask for fees. At the end of the mediation, you are told, Mpayo, where is it? So can the judiciary make it very, very clear? Because as we know, it's free. But at times, we are told to pay money at the end of the mediation. Let each party bring this. So come out clear and tell us when we are starting mediation, is it free or we are supposed to pay? Then I also wish to, another problem I've seen in mediation are the short notices for the mediation hearings. It is my humble prayer that the notices are sent out way in advance. Like, for example, the cases have a cause list. Why can't we have a mediation cause list set out way in advance so that the parties know when the mediation is going to be, than having a call on a Sunday? Even at times the calls come on a Sunday. You have mediation tomorrow at this time on a Sunday afternoon. So let us have a mediation cause list. Then, as I said earlier, family division is different. Under the laws, it says 60 days for mediation. I request the Court of Emotions, let us extend the time. What applies in commercial law cannot apply in the family division. You cannot say 60 days, no. I think we need more time in the family division because emotions are involved. People need to cool down. You can't give them that strict days. When revising the rules, kindly extend the time for the family division because of the emotion involved.
Council, you have 5 minutes.
Okay, I'm going to be fast. Then the mediators usually allocate about 45 minutes to each mediation session. This, in my opinion, is so short because these are matters which involve emotions and they should be given more time during the mediation. I also request that security be provided during mediation. Some parties become errant, they quarrel, and there's no security nearby. At least let someone stand by the door, but not very far. I feel we need some security in mediation. Then I talked about the difficult litigants who come. There's a problem. For them, they want to litigate. They come with a closed mind. They don't want to have any mediation. This applies to both the parties and the litigants who come with those closed minds. Then there is the issue of visiting locus. I also request that mediators, there are some matters where they should visit the locus, not just sitting in their mediation rooms and mediate. There should be visitation of locus. Then another shortcoming is the training of mediators. Most law schools do not teach mediation, yet some have begun. I know Mukono has begun, yet mediation is the way to go. LDC has now made mediation a compulsory course unit. So I request that the universities take up mediation as a course when they are teaching law. Okay, I've already talked about the lawyers who want to go to for full-blown trials because they want to show off that they are lawyers and they should impress their clients. Then, as mentioned earlier, this is a court of emotions. I won't stop saying that. I highly recommend that we have counseling. The judiciary should think about counseling and therapy in the courts. You can have mediation better done if the parties are counseled, if the parties have therapy. It eases mediation. In Australia, there is court-ordered therapy. In the state of Florida and the US, there is court-ordered therapy. This usually applies in the courts to do with children, family issues, drug abuse. So I would invite our court to think about counseling and therapy in the family division. It would easily ease the work. Then lastly, there is the issue of telephone numbers. It would be important that apart from the mediation registry picking the numbers of the lawyers, pick the numbers of the parties. Because the lawyers may not have interest in mediation, but the parties, if you called them, they could come. So pick both numbers of the parties and mediators. In conclusion, mediation has helped a lot to ease it eases the work of the court, and I highly recommend that it's done. However, the lawyers should be sensitized on the importance of mediation, and the public too, because mediation has a lot of benefits.
Thank you very much, Mrs. Ndiko. You also worked within your time. Can we have Dr. Atim, please? Dr. Patricia Atim. Thank you.
Yes, before I begin, can I request the technical team to please assist me with the slide thing? Yes. And then, good morning, my Lord, Justices, my lords. I would also permit me to stand on the protocol that has already been observed. I bring you greetings from the School of Law, Makerere University, because I'm here also as the IDLO consultant who has worked on a paper for IDLO, a section of which is being presented here today. but also my principal, Professor Ronald Naluwairo, who was invited to this occasion, asked me to represent him and also deliver his regards and apologies for failing to attend because of some personal limitations. My instructions are to talk about the trends of jurisprudential trends since 2022. And before I commence, I would request that the technical team plays the video that I thought would be useful as a precursor to this conversation and to contextualize what we are talking about since the speakers have said since morning. So the technical team, please, it's a 3 minutes video. Chair, I hope it will play out.
Moses Rokidi omusubuzi w'omu Kampala yeyeezoba ne nnyina Maria Paulina Namwanji yatemera mu gy'obukulu 45 mu mbuga z'amateeka ng'ayagala ave mu maka ge yasikira olw'okuba si wampeta.
Ng'agamba nti mukyala wa kitange naye nze mbagidde ebbaluwa ya kitange
Technical team, the video.
Nga ye tali mu bbaluwa eyo nti ye mukyala wa kitange.
Rokidi takomye ku kyakwala nnyina ave mu nnyumba.
It should show.
Kirabula kati yasibye kooti emulukusa okukebera endaga butonde yamu ku baganda be bagamba nti nnyina yabenda.
Naye bo bennyini be nagisabirako bagibakole ne bakkiriza kyokka olw'okuba omukadde nnyaffe yamanyanga bajja
mu Kampala yeyeezoba ne nnyina Maria Paulina Namwanji yatemera mu gy'obukulu 45 mu mbuga z'amateeka ng'ayagala ave mu maka ge yasikira olw'okuba si wampeta.
Ng'agamba nti mukyala wa kitange naye nze mbagidde ebbaluwa ya kitange ey'obufumbo ngirina nga ye tali mu bbaluwa eyo nti ye mukyala wa kitange.
Rokidi takomye ku kyakwala nnyina ave mu nnyumba gye yasikira wabula kati yasibye kooti emulukusa okukebera endaga butonde yamu ku baganda be bagamba nti nnyina yabenda.
Naye bo bennyini be nagisabirako bagibakole ne bakkiriza kyokka olw'okuba omukadde nnyaffe yamanyanga bajja kuzuula ng'abaana abo teyabazaala ku kitange. Bajja kukola DNA ebyantu ebyali bimanyiddwa nga biri ku kaalo mpolampola bizuuke.
Ono era azzeemu n'akkaatiza nti wadde nnyina amuzaala nti yali wampeta bwe tunamuyukiza nti wadde amaze emyaka n'ebisibo maka gano talinamu bwannannyini bwonna.
Okuba okuzaala n'okuba omufumbo byanjawulo. Abantu bangi bazaala nga si bafumbo. Oba mmange yanzaala nga si mufumbo eryo lyali ddembe naye ate ekyo tekikuleeta kugamba mu kkooti nti ndi mufumbo. Kitange yawasa omukazi ng'ennaku z'omwezi 7 Julaayi 1945 ne marriage certificate weeriwa.
Namwanji nnyina wa Rokidi yagamba nti ku baana bonna be yazaala tewali gwe yazaala bbali w'amaka gano era ne bba yafa bakakasiza mu buwandiike 1999 Mugomo.
Kitaawe talekanga ng'aga nti abaana si babe. Yali musajja mukozi wa gavumenti, yali amanyi okuwandiika, yali musiru. Abaana bendese, abaana bange bennina yegundi negundi. Kati gwe ng'omwana oyinza otogga nti abaana abo si bataata. Ng'ate ye kitaawe yakiraki. Omanyi owandiika abaana b'ozadde empapula n'ozitwala mu kika. Ab'ekika ne babayingiza mu bitabo.
Namwanji agasseeko ne mutabani we asusse okumusujja n'atuuka n'okumuwa amagezi agende afumbwe wala nga kwatadde n'okumubuuza ddi lwalifa.
Gwe omwana wagambira nti okyali mbooku genda ofumbirwe ozaale n'abaana. Abamalaya muzaala ng'enkejje. Mutuzaala ng'enkejje nazaala abaana bangi n'ensibya kitaawe omukisa gw'obugaggawala.
Ono era agamba nti yeewunya omwana gwe yakera ku makya n'azaala okumulisa akanje n'atuuka n'okwagala okumuguganya maka ag'obufumu amaze emyaka egisiba mu 67.
Kubanga taata we yeyanjija owa taata ne maama nga ndi mwana muto sifumbirwangako.
Omukulu wa Rokidi omu ku baayagala bakebere bw'endaga butonde Sansa Michael agamba nti mwana wa kitaawe ga bigogo nga muto we anoonya byanfuna.
Era bwe twali nga tukyali nga ntandika nga mpubuse yampa ekibanja nampasiza omukyala nangulira omukyala nampa nembeera teyansosola. Kati obanga teyansosola kidi omwana omuzinga mukulu we amanya atya nti nze siri mwana wa kitaawe.
Omu ku bulugalo lwa Gabigogo akkaatiriza nti Namwanji bamwanjula amaka ag'abazadde mu 1948.
Ddala nze nagenda ne mukulu wange netugenda tumugula.
Emboozi ntwasooka kugikulaga mu kulirika fakataliiko nfoofo nga ennaku z'omwezi 8 omwezi gwa 11 omwaka ogwedde omwana Rokidi lwe yasooka okutwala nnyina mu kkooti nga mulangira obwenzi n'agatako n'okumukanda okuva amaka ge yasikira. Jacinta Bwanika yakusakidde eggulu eno ku Lwabukedde TV.
Yeah, in another circle I wear a clinical hat, so in clinical legal education we want to use such documentary to also bring home the realities of our society. So this is what we are talking about: family relations, succession law, dispute of property amongst family relations, as you can see. And the gentleman suing the father there is not a child necessarily, by definition of the standards of who is a child. Technical team, may I please have the PowerPoint back? So my submission today is focusing on jurisprudential trends on succession law in Uganda, the Post-Succession Act, Amendment Act of 2022. This period, I hope this works. Technical team, you will move it from there probably, the sensor. Yeah, we've watched the video. We start from the basics, the definitions, but in the interest of time, I'll not get to that since I'll assume we all know. Back in history, our Succession Act 2022 emerged from way back in during the colonial times, which was a succession ordinance of 1906 that we embraced with the advent of colonialism. Following that succession ordinance was amended, or rather revised, in 1964, to which became the Succession Act Cap 139. In 1972, our president then, Dr. Idi Amin Dada, amended the Succession Act using the Succession Amendment Decree number 22 of 1972, and that is what we have been utilizing. Rather, that amendment and the Cap 139 is what was later revised to become the Succession Act Cap 162. The Succession Act Cap 162 is what applied for a very long time until 2022, when we adopted or enacted the Succession Amendment Act, which was recently consolidated in July. Some faces I see here attended that launch. The 7th edition of our Laws of Uganda was launched. The laws were revised, and now the Succession Act Cap 162 and the Succession Amendment Act Cap of 2022 have been married into the Succession Act Cap 268 with the launch. So a little bit into the historical legislative transition. Sorry, I'd gone back a bit. Now, before we embraced our Succession Amendment Act 2022, now Cap 268. Of course, there was a lot of activism by many people, the women's movement, scholars, and also the courts made their contribution. In a number of judicial decisions, we have progressive judicial decisions that infused human rights perspectives, especially for the protection of the rights of women in law, and that have also informed the amendments we now see in the Succession Amendment Act 22, now Cap 268. And those are some of the decisions which some of you may be familiar with. The Best Kemigisha case is the one that granted the Queen of Toro rights to administer her husband's estate at a time when women were not held to be able to administer estates. The Law and Advocacy for Women decision dealt with a number of issues, including the declaration of various sections of the Succession Amendment Act as unconstitutional. The Fida case, and then Elizabeth Wamala and Jolie Kasade dealt with the question of separation of spouses and succession, because as you recall, in the old law, a wife who was separated from her husband before his death would not benefit from the estate. And in Elizabeth versus Kasade, that was challenged, and the court made a pronouncement that it denies women and spouses access or their interest in matrimonial property that is acquired during the life they live together. And then those are Asimwe versus Asimwe is very important also, because it dealt with the distinction between illegitimate and legitimate children. Justice Catherine Bamugemereire there wisely held that in Uganda we do not have illegitimate and legitimate children. We only have children. Once a child is determined to be a child of the deceased, the child must benefit. And you can remember from the video that old child was claiming that some children should be subjected to DNA. Then Collier versus Collier is also a good decision in saying that the matrimonial home, which in succession law we refer to as the principal residential holding, should not be distributed or bequeathed to the disadvantage of the wife. Because in Collier, a grandchild was suing a grandmother over interests in the matrimonial home because his father was the heir of his grandfather. Okay? So the objective of this session really is to tease out what are the decisions, how are we to trace what kind of decisions are emanating from the courts now following the 2022 amendments and now CAP 268. With this decision, for instance, I just looked at the key aspects that were very controversial with the old law, issues to do with the rights of lineal descendants to take interest in property. We have Nasuna Mili and another versus Chiwanuka and another, a dispute between lineal descendants of a mother, daughters of a mother, who had been disenfranchised of their interest in the estate by an uncle who falsely obtained letters of administration. The court, rightly applying those sections of the Succession Amendment Act, found that the girls were lineal, the children were lineal descendants and entitled to an interest in the property and also to obtain letters of administration, and cancelled the letters of the uncle that the uncle had obtained fraudulently. We have Michael Chirunda and another versus Jessica Chirunda. That is also interesting because this is a dispute between grandchildren. The two petitioners there are grandchildren of Chirunda, a grandfather, and then Jessica Chirunda is a daughter of Chirunda. The grandchildren sued their aunt for revocation of letters of administration on grounds that their aunt was actually mismanaging the estate, etc. And the court then had to deal with between these two lineal descendants, because when you look at the definition of lineal descendants in the Succession Act, it's quite broad. It includes the biological children and then other lineal descendants in line with the deceased of the deceased. So even grandchildren of the deceased are lineal descendants. But now when two lineal descendants are disputing who has priority, the Succession Act does not provide explicitly who has priority between the two, but court in its wisdom at least held that Jessica Chirunda, being a daughter of the deceased Chirunda, had the priority rights to obtain letters of administration above those of her nieces, Michael and Michael Chirunda and the rest. We have Namubiru Betty and Winnie versus Saulo. That was a dispute between lineal descendants and customary heirs. The question of customary heirs and their 1%, and customarily them thinking that now that gives them entitlement to the entire estate, has also been re-echoed in the Succession Act, Amendment Act. When you look at it, their percentage in the intestate distribution is 1%. And then the courts have also re-echoed and reiterated the role of succession, rather customary heirs, as not a position that automatically entitles you to the estate. And in the interest of time, I cannot read the quote, but it's a very beautiful quote that I think it was Justice Sisi who decided this decision. I could remember. Yes, she clearly restates the purpose of a customary heir is a cultural function which does not bestow legal authority on a person to deal with the property of the deceased. They must also apply for letters of administration, or if other people have letters of administration, then the customary heir's role remains limited to ceremonial and entitlement to the 1% as provided for. That decision has also, and the position there with relation to customary heir is also reiterated in those other decisions that dealt with the same question of interest of lineal descendants vis-a-vis that of customary heirs. And where you find customary heirs, go ahead and obtain letters of administration in order to begin to intermeddle with the estate. We have now another decision, Jane Chorayende and Chomukundi, as you can see. That is a decision that deals with the rights of spouses to obtain letters of administration and the interest of a spouse in the principal residential holding. A decision from Barara Court, His Lordship, I think, Alan and Nshime. And this is important also because for a long time, the interests of spouses, especially women, to obtain letters of administration and also to retain an interest in the principal residential holding remains critical. But we see that the courts are breathing life into the amendments brought by the Succession Amendment Act, because the Act under Section 201 clearly gives the widows, or spouses rather, priority right to obtain letters of administration. And this was recognized by the Land Justice in that decision. And also, having proved that she's a wife of the estate, the daughter, who was her stepdaughter but an older stepdaughter, similar to the video that we had seen, could not throw her out of the matrimonial home. She had to enjoy her rights in the residential holding, and that's the court also cites Cholia versus Cholia, which we cited above as one of the cases that inform the changes we are now seeing in our law. Then although that is a good decision, I pause and think we should reflect, because this is a summit we are debating. I looked up the definition of a summit, and it said where experts debate critical issues. It's a space. So now your experts' views that are being shared by other experts. So we should think, when you look at that decision, Cholia versus Cholia, and also the video keeping in mind, and the other case that we've talked about, how about if the widow has to remarry, does she lose her interest in the matrimonial property? We have to think, because before a spouse dies, you already have an interest in matrimonial property as a spouse. So do you lose it? Because the law also still says you lose the interest in the residential holding upon remarriage. We have to think critically. What do we do about such circumstances? How about instances of polygyny, where men have more than one wife and they have many children from many other wives or partners? What does that mean? Do the lineal descendants of that man, as you have also seen, all of them come, whether they are the biological children of this particular surviving wife or not, do they all come and take an interest in the principal residential holding that has been left behind? Those are questions we have to think about. The previous
Kindly
laws...
conclude, please.
Oh my God.
Okay. We need
Okay.
time for discussion. That's why we're limiting the...
Yes, I understand, my lord. So we have also the cases that are coming up in protection of the issue of separation of spouses in the matrimonial, spouses who are separated from the deceased at that point of death, or at the point of death. This decision, Mirembe Masiko, and there is Patricia Were. In both decisions, children are fighting their stepmothers to exit the matrimonial home because they were not taken interest in the estate, because they were not there at the point of death. And in both circumstances, the deceased had caused the departure of the wives. And our Succession Amendment Act now says, where a deceased is at fault and causing the separation of another spouse, then this section about losing interest in the estate shall not suffice. We see the courts are continuing to hold administrators liable for mismanagement of the estate as provided for by the law. The courts are awake in that and nullifying transactions that entered into fraudulently by administrators to disenfranchise beneficiaries in the estate in those two decisions. The purchasers of estate property are, even with fraudulent intent, are hiding behind the concept of bona fide purchaser for value without notice, but the courts in those two decisions have been wise enough to lift the veil and see beyond their fraud and not hold it. So what are the emerging issues that we see still remaining? One, the judges are alive to the reforms in the Succession Amendment Act, the judiciary, and that is very commendable. There is increased protection of women and children in the distribution of the estate, but there's limited application of the international and regional instruments or conventions that Uganda is party to. The judicial officers are simply applying our local law, but the Constitution mandates us to respect the international and regional instruments that we have ratified. So we need to read these and breathe life into them in our decision making. The issue of burial ground remains very contentious. The Succession Act does not have any provision on burial grounds or determination. It's left to the executor or the person who immediately takes over possession of the estate. However, you will be reminded by those decisions that have dealt with the question of burial grounds in our spouses, children against their father, her wife against a mother-in-law. So there is need to embrace alternative dispute resolution mechanism. And this has been said, I will not press it any longer. The book we cite there is written by our Justice Kiriabwire, and it's a very excellent book in ADR. I enjoyed reading it with even the traditional African mechanisms talked about. The technical team?
Oh, no.
Yes. When we deliver good judgments, we breathe life into our commitments under the Sustainable Development Goals. All of them, apart from two. If you go back and visit them, you will find that a good decision that meets the aspirations of the people in light of Article 126 of the Constitution will also lead Uganda to enjoying or attaining the Sustainable Development Goals that we have committed to achieving. Sticky issues remain. The question of matrimonial property rights versus spousal rights upon death. We must determine. Marriage bill, that drum has been drummed, and I hope we shall get there. The status of couples in cohabitation. Parties in cohabitation were even debated in Parliament. I read the Hansards. The Speaker made her statements. It would be interesting if I had time to read out, But if you read the Hansards around the debate of the succession amendment bill at the time, the status of cohabitation couples was discussed, but it's interesting that they were not provided for in the Succession Amendment Act. Yes. So we need to address it, because I'm waiting. Previously, we had 64% of our population living in cohabitation.
Please, let's close this, please, so
I'm
we can
closing.
have time for discussion. There are lots of issues
yes,
that will come out of this.
Yes, my Lord.
Thank you.
Thank you. In the minute, judicial activism is still important to address some of the gaps that still exist. We are relying on you. And then, what did I want to say? Parliament must continue to also look at the laws and pass law to address the lacunas that we still have. My lords, justices, and the House at large, I am most obliged. Allow me end here. Thank you very much.
Thank you.
Thank you, my lord.
Okay, thank you very much, Dr. Atim, and all my able presenters. Can we have another round of applause for them, and then we get into question time. So numerous issues have come out of this. First, the public is clearly ready for mediation. Secondly, there is need for attitude change, the impact of family disputes on children, the informality, confidentiality, and party-driven nature of mediation is conducive for family cohesion, but there are lots of sticky issues that remain. We shall have question time. We have about 50 minutes. So time for questions. Any questions? We'll take 5 at a time. And kindly identify who you are addressing it to. 1 question per participant, please, to let everybody get their say. Thank you. My Lord, the Deputy Chief Justice.
My Lord, thank you very much. And really let me thank the mediators for brilliant presentations. My concern was on one. We were told that the mediators are asking for fees. This is a big, big problem, and I think we should solve it. The presenter did not seem excited about telling us who is doing this. May I request for a whisper to the Chief Registrar? We shall solve the problem.
Thank you, my Lord. Any other questions, comments? Justice Chiriabwire.
Thank you, my Lord Chair, and thank you all presenters for a very enlightening session. I wanted to start by saying that probably in future also, in terms of family justice, we should be looking at what happens on appeal, because now we're starting to get a lot of matters coming on appeal, which started either as matrimonial or succession, and they're coming into the courts of appeal, and we're settling them in a way that resolves the dispute that keeps them right out of the courts. And I'm wondering that, one, the experience that we have seen has shown that probably at the trial stage, we should encourage some form of hybrid, even if litigation ensues, some form of hybrid so that you can thrash out what has been agreed and what has not been agreed, and therefore come out with a resolution. And I say this because, one, I'll just give very quickly short examples. You have a decision where custody is given to the wife, and the father is absolutely unhappy about 100% custody. And on appeal, you go through a period of trying to see how you can share custody. And at the end of the mediation, the wife says, you know what? I've changed my mind. Let custody go 100% to the father. This we have done. We have had cases where property has been distributed, matrimonial property, in one way or the other. In the cases that we have seen in the Court of Appeal, mostly largely to the woman's spouse. And she gives it up. She gives up portions to the male spouse. And one wonders why that has now been realized on appeal. We have also found it necessary to include third parties who are not parties at the trial, but who have an impact in resolving the dispute. So I'm wondering whether some more emphasis, not just mediation pure, but some form of hybrid, even when litigation takes place, can be done. And I would like to really thank Council Ndiko for her exposure to the problems that Council bring into this. I think we need a very heavy discussion with the bar to embrace mediation. And one of the things that we should be doing as we deal with this is to do more and more training, because the roles are problematic. It is true, as Council Ndiko said, that just to get the lawyers to sit at the back and the parties to sit in front is an exercise in itself. And I think this will come out during training. So this is an open comment. Anybody can respond. Thank you.
Thank you, Justice Chiliawili. I think that is Fiona Wall. Yes.
Thank you, my lord. Thank you so much, Dr. Tim, for bringing things home. I just wanted to ask, in regard to your last comment, on your last recommendation regarding international instruments, have you observed any particular areas that could have been aided by these international instruments, any gaps in our jurisdiction? I think if you have any, since you've done extensive research and you're an academic, it would really help us. Then, Madam Ndiko, thank you so much. Counsel, sorry. Your name precedes you in family justice practice. But so how would you advise a mediator to manage the psychosocial issues? You've mentioned counseling and therapy, but these are long-term things that might not be practical during the so what are those tips that come from a legend?
We'll take 2 more questions and then give room for answers. There is a question at the back there. I'll have Justice Obura. Do you have a microphone? Yes, please go ahead.
Thank you, my lord. I will adopt the protocol as earlier given. My name is Anne Karunji, and mine is, I have 2 comments to make. The first comment is in response to the comment that has just been made by His Lordship, the Deputy Chief Justice, on mediators asking for fees. We are in this room having a conversation which is pertinent on mediation because of the backlog, the enormous backlog that we are facing as a country. It is important to take note that how are we going to attract persons into the field as mediators when we shy away from the conversation of fees? I, for one, am a lawyer with my practice, but I am interested and very interested in being a mediator. But how do I leave my law firm with the expertise in family law that I have and put in my 5 or so hours to mediate on matters without having the conversation on fees? It is important that as we raise this conversation with Parliament and other stakeholders, that the question of fees, as has been done in other countries that we are benchmarking from, be put into consideration, because it will attract us into, the field to help, courts handle some of these matters. I thank you.
Thank you very much, Ms. Karunji, that His Lordship will answer you right away.
And also, lastly...
No, one question, please. Let him respond, and then we...
Let me explain that fees are different from costs. what we have been doing at the Court of Appeal and other courts do is that advocates who participate in mediation are entitled to payment from their clients for mediation, and the presenter stated it clearly that he charges his clients. We encourage you, stay in court, go to court for mediation and negotiate your costs, and they will be paid openly in court. Don't go behind the parties and ask for fees which are different from costs. That is the difference. We are not worried about you being paid for mediation. You should actually be paid. It's legitimate, it's proper. Advocates take up cases. If they are settled through mediation, they should be paid for the exercise. I think what the presenter is worried about something else, not yours. He's worried about kitu kidogo.
No. My Lord, point of correction.
We shall move to, I think we'll have the discussion after. Let's have the questions in, and then we open the floor for discussion. Lady Justice Obura.
Thank you, my Lord Chairperson. I wanted to share my experience on what played out before me last week when I was mediating a divorce case, just to drive home the point that lawyers can be a stumbling block and therefore they need to be sensitized. This was a divorce case, and the lady came with her lawyer. The gentleman is a lawyer, he came alone. And then after my opening remarks, where I had indicated that at a later stage, where necessary, I could caucus with one of the parties in the event that they feel that there's something confidential that they want to tell me in private. Immediately, the lady put up her hand and told me that I want to start with that. I want to talk to you alone. I want my lawyer and the gentleman to get out. When those people got out, she said, "My Lord, I don't want my lawyer. Please tell him to get out, because he's a stumbling block. We have already had discussions with my husband and his father and my brother, and we have already agreed on what should be done, and I have no problem with that. But when I informed my lawyer, he told me, no, you have done a wrong thing. We are ready to fight this man up to the Supreme Court." And the lady complained. She said, "Look here, I've already paid a lot of money to these people. This matter originated from the magistrate's court." She said, "Even the appeal to the High Court, I was not interested in it, but they forced me. So please do me a favor. What I wanted from this gentleman, he has already done it. I don't want to stress the father of my children. He's paying their school fees. He already has high blood pressure as a result of this. I'm not part of fighting him up to the Supreme Court. Just do me that favor." And when I called back the lawyer and the other gentleman, I informed him that actually your client prefers to handle this mediation without you. He said, "And I'm requesting you to kindly step out." When he stepped out, I resolved that matter within 20 minutes. We were done, and they have already signed the settlement. Thank you.
Thank you very much, Lady Justice.
Sorry, I wanted to propose that let her be part of the team that is sensitizing Mrs. Ndiko. Let her be part of the team so that she can use her experience to encourage other lawyers. Thank you.
Okay, I think Uganda Law Society has some work to do. We have a past president in the room, and we have a vice president. Kindly take the message from this summit. With that, I shall have our panelists respond to the questions, then we'll take another set of questions. Mrs. Ndiko is taking about two questions. The one on the fees to supplement the Deputy Chief Justice, and the last one from Justice Obura. Then the rest shall take the other.
Okay, I'll start with the one of the fees. As far as I know, the mediators are paid by the court. I think so. But at the end of the mediations, some come up and say, can each party give me this amount of money? I'm not saying all, but a few, but it happens. And it frustrates mediation, and that should stop. I'll whisper to the CR at the end of this mediation. Then, yes, I want to argue with Justice Obura that yes, lawyers are a stumbling block. I also feel it personally when I'm in court. I'll give an example of a matter last week whereby my client was ready to withdraw her petition for divorce, but the husband had filed a cross petition. So I told Justice John K. Chidima that we are ready, but the other lawyer told me, no, I can't withdraw our cross petition. First of all, you are rich, you're a senior lawyer, you've made money. I also want to make money. So if I withdraw the cross petition, I'm going to be at a loss. So the matter has stalled because the lawyer wants courts. It's true, we are the biggest stumbling block in mediation. Then there is the issue of psychotherapy help. It is my request that this be done by the courts. Let the courts get therapists or counselors and employ them to work in the courts to deal with the mental health, to deal with the mental issues concerning the parties. That is my request. To have court appointed counselors or therapists to help in such causes.
Thank you, my lord. Thank you, Advocate Wall, for the question that you asked. It was whether any of the gaps would still exist without the application. Well, from the decisions that I reviewed, like I said earlier, there is no application of the international regional instruments. We are not seeing it there. Although I think even if the judges had applied them, the results, the pronouncements they made were still positive. It's just that reading in these international and regional instruments would enrich the jurisprudence. And because as a state also we are required to comply, oblige, and also interpret some of those provisions in our laws, we are a bit lucky that now with the progressive laws, most of the laws are beginning to also resonate with the commitments we've made at the international or regional level. So if you look at earlier decisions, for instance, I'll take you to them. The Uganda Association of Women Lawyers, Uganda versus Yiga Hamidu, Uganda versus Nakaupet, those are the decisions that have a bearing on family justice and so on. And you'd see that the court went an extra mile to infuse the Convention on Elimination of the Rights, Discrimination Against Women, the provisions of the International Convention on Civil and Political Rights, the African Charter, and the treaties therein into the reasoning of their judgment. And it really makes it rich. And maybe because I come from the academia, we want to see those so that when we also engage the students, they're able to see that actually these international instruments apply even in our domestic sphere. And thank you very much.
Justice Chiriabwire, the hybrid approach, how can we separate issues, resolve some and settle others? My experience in the family division actually shows that when parties have come for a divorce, they are usually agreed on one thing, to separate. That's a common ground. Now, the contentious thing in a divorce is about custody and property. So that's why at times, when at times we have these partial consents, we have at times been criticized of saying the parties have colluded. Collusion, in my own view, is if a party is accepting to agree to a ground which he has not committed. But if a party is saying, yes, I have committed adultery, and I accept, that cannot amount to collusion. But I can understand why at times the parties are so agreeable on that point. It's because they don't want to bring out the dirty linen for the grounds. And by that time, they are fed up with each other. So really, in a divorce matter, the contest is custody, and property. Now, application of international instruments, yes, to some extent. But for example, if we are defining marriage here in Uganda, and you want to apply an international instrument to that same definition, you might have issues. You might have issues. But that's not to say that it's not good to apply international instruments. The other aspect is about the issue of fees. I think the council, what council was talking about was about if they are to participate in these mediations as mediators, what is in it for them? The good news, I think, is that we have developed regulations. The fees might not be that much, but at least it will not be totally pro bono. Much as it's a social responsibility, which I think council should take, but we are developing regulations which I think will remunerate mediators, especially if they are from the bar, and I am sure some of our court-accredited mediators have already benefited from that arrangement. For example, I know that a successful sitting is we are going to be paying 300,000 shillings. You might not earn that money in your chambers in a day. If you are very lucky and you come and settle a dispute, at least you are guaranteed of that remuneration. Even if it fails, by the way, you still are paid. So don't get worried. Please come out and let's do this work together. Now, about counseling, yes, you see parties who, even in a mediation, by the way, the parties are not on the same ground. They are very powerful ones who will talk all the time, and they are the quiet ones. Then you get somebody saying, for me, I just want to get out of this thing, even if I don't get anything. We have those type of situations. So that's why it's important at times to have a caucus and talk to these people. And when there's a caucus, they open up to you and tell you why they are so aggrieved. And in that way, you are able to. So in other words, I think as mediators, actually, we need those counseling, the counseling training, because I have always told people that in most cases, in my experience, when women are reporting to you, they usually come out of your chambers crying, and somebody who's waiting for you outside may not understand where they are coming from. So you just understand that when you see these women crying, you know that we are just because they are telling stories which they don't feel they want to tell in the open. I think that's basically it.
Okay, thank you very much. Next set of questions. I've seen Dr. Livingston Sewanyana. Yes, please go ahead.
Thank you, Lord Chair. I want to direct my question to Justice Katerima and Justice Nagawa. In principle, I would like to know what is the current court practice regarding declaration of inventories. Often and upon grant of probate or letters of administration, it is stated that the parties in question will render an inventory. Do courts actually examine these inventories? Do they require them? Do they ever demand that these inventories be furnished to the courts? Because there's a lot of miscarriage of justice that takes place in the distribution of the estate. And would they, for example, as courts, see a role for the mediator in terms of reviewing the inventories if they are so furnished? Thank you.
Thank you very much. Her Lordship, Justice Wolayo.
Thank you, my Lord Chair. I'm just concerned with the absence of a remedy after a mediation agreement. So supposing facts emerge later, there was some probably misrepresentation of facts or non-participation of very important, very critical parties. So shouldn't we provide for some kind of remedy, under limited circumstances? Because there's no appeal, and that is understandable. You cannot appeal something that you have agreed upon. Now this brings me to my second point, and that is the requirement under the mediation rules for parties to reduce this mediation agreement into a consent judgment, to enable execution, etc., etc. So recently I was faced with a case where parties had agreed, there was a mediation agreement, but the magistrate had not signed off a consent judgment. It wasn't even, nobody had drafted it and presented it to that magistrate. So this party comes to me, to the High Court, for consequential orders for me to enforce that mediation agreement. Now at that point, I felt I couldn't make that order, I couldn't enforce it because there was no consent judgment. So there's this requirement for consent judgment. How can we make sure that this happens so that we avoid this kind of, scenarios where people have an agreement, but it cannot be enforced? Thank you.
Thank you very much. Yes, please go ahead. And then after her, we shall have the Administrator General.
Thank you very much, my Lord. My name is Rachel Odoi Musoke. From the JLAW Secretariat, but also a court-accredited mediator. My question is, I think, partly to Dr. Atim, but maybe also to the judicial officers. The question really going back again to the issue of international and regional treaties, but my question really is, our family justice is so heavily influenced by our custom and our culture. So have we seen in the jurisprudence, how do we balance the two? There was a question raised, for example, about the matrimonial home where a widow remarries. I think the question doesn't arise for a widower. That starts to conflict with our international law. Do we begin to see any kind of jurisprudence that's addressing the dichotomy between the two?
Thank you, Rachel. Yes, Mr. Kasiwayo. I think we'll take. We please have a microphone get through to him. In the meantime, we'll take a question from His Lordship Justice Mzami Ruchibedi as a microphone gets through to Mr. Kasiwayo.
Thank you, my Lord Chair. Mine is not a question. It's just a remark. I just want to correct the impression which appears to be arising that lawyers, advocates, are a stumbling block to mediation. That is not 100% right. They can be catalysts or they can be stumbling blocks, depending on who they are and how they are handled. The moment you go to a mediation with the mindset that the lawyers are a problem, be sure you are going to get bigger problems. Lawyers are trusted by their clients. Most lawyers, I had that experience while still in private practice. Some mediator chased, as it were, one of my lawyers. So when she rang me, I said, don't bother, get out. And there was no deal, even in the absence of our lawyer. But when we engaged and reported that matter and counseled our client, a deal was eventually got. So we should appreciate that advocates are key and critical players and partners in this game. Let's invest in them. Let's ensure that we work on their attitude. Let's also know and improve on how we handle them if we want results. And that question of fees, it is a legitimate issue. It should be discussed. At what stage? Counsel Ndiko has given us a clue. For her approach is discuss with your own client, agree on the fees, and move forward. That is what has worked for her. Once she shares such experiences with other people, they can also see what can work with them for their particular clients. And together we shall move forward.
Thank you very much, my Lord, for that perspective. So we shall now have Mr. Kasivayo, the Administrator General. We shall have responses. Mr. Mutabingo, I've seen your hand. In the next set of questions, we'll take you. And Mrs. Shonubi. Yes, Mr. Kasivayo.
Thank you, Chair. I wish to supplement the presentation of Dr. Patricia Tim on the history of succession law in Uganda and its application. When the 1906 ordinance, succession ordinance, was introduced, it did not apply to the natives in Uganda. It only applied to the foreigners who were here. There was exemption order made under section 337 of that succession ordinance that exempted us, the native, from the application of the succession ordinance law. It continued as it was amended in 64, as she has put it, but still it was not applying to us, the natives. It is only Uganda which had a written law called the 1912 Succession to Land in Uganda. All other natives had their customs applying in succession matters. In Toro, for example, when the head of the family died, the entire estate vested in the customary heir, as it was decided in Mwesugwa Sharp, and it would be the customary heir to distribute it. In Karamoja, for example, they used the kraal system. So it was not until 1972, under decree number 22 of Idi Amin, that the Succession Act began to apply to us, the natives. Even when the kingdoms were abolished in 1966, Benaisa, then the Attorney General, made statutory instrument number 181 of 1966 still to continue exempting the natives from the application of the succession law. Now, when the kingdoms were abolished in 1966, for Uganda, for example, who were applying the only written law of 1912 succession to land, there was a statutory instrument made in 1967 called Statutory Instrument number 150 that transferred the succession registers of Uganda to the Office of Administrator General. So I thought that clarification should be made clearly on when the Succession Act began to apply to us, the natives. It was in September 1972. The second last comment, Chair, is on matrimonial property and residential holdings or other residential holdings. There has been commingling of the two, and it has come up in some decisions. Now, the succession law does not have any wording on matrimonial property. Matrimonial property is a creature of the Land Act under Section 39 about spouse consents on disposal or mortgage. And it is defined there as a property where the spouse live and deliver their sustenance. It can include a home, gardens, and a farm. Whereas the language of succession, which is put in the Succession Act, is the principal residential holding and other residential holdings, which simply refer to a homestead where the deceased lived with a spouse or the lineal descendants who are entitled in that category 25 years and still in school or dependents. So I thought I should make these additional comments. Thank you.
Thank you very much to the Administrator General. Extremely useful insights. Extremely useful insights, thank you. We shall have responses to our questions and then take a final set of questions.
I'll answer Mr. Sewanyana's question on inventory. Yes, inventories, the court takes keen interest in filing of inventories. And how do we get to filing of an inventory? An inventory is only created upon issuance of letters of administration, and that's when it starts counting. And before issuance of letters of administration, just to take you a step back, there is a petition where the petitioner could have filed stating therein the beneficiaries of the deceased, which is very key, and the assets of the deceased. So after identification and all that, letters are issued. And if you look at the letters very closely, mentioning the executors or the administrators therein, the second paragraph talks about filing of an inventory within 6 months and final and full inventory before expiry of the 2 years. Lately, the letters expire. Before they used them to expire, but now they run for 2 years. And that is where the story of the inventory begins from. The 6 months, and then the final and full inventory after the estate is presumed to have come to an end, because you have to. It's not in perpetuity that you're going to operate as an administrator or executor forever. And now the issue you have, Mr. Sewanyana, is, do we consider? Yes, we do. Section 2731 of the Succession Act requires the administrators or the executors to file an inventory. And what do we consider? That's when we bring out that mother file that you prepared and brought before court. You don't know, but we know. So we pull it out, we join it with a file for the inventory. And in your inventory now you're telling us the beneficiaries have either increased or reduced. Remember, you would have stated them in the petition. The assets are now less or more, and this is how you would have distributed them. Stating maybe the children, you've given them these assets that you could have mentioned or you could not have mentioned. And your story begins there. That's when the judicial officer is asking you, how did you know about these assets? Why didn't you disclose them? I imagine you said the deceased left 30 acres of land in a particular place X, and now you're only disclosing 3 acres. So the question is, why the variance? Why is it more or why is it less, and why have you distributed like this? Of key interest is that when you file the inventory, it is prudent you serve the respondents. And who are the respondents in this case? The respondents are the beneficiaries. These people that you have stated in your inventory that you distributed the estate to them. So they appear before the judicial officer, and the judicial officer wants to find out, is it true that you got A, B, C, D? Because at times the administrators or the executors filed to say they did, and yet they did not know. They did not. So there it goes on and on. Some say, actually, we have never received anything, or indeed, we did receive. And some will say it's intact. So it's about the parable of the sower, the Bible. You gave me this, but I feared you, and I decided to keep it under the table. I didn't do anything. So the judicial officer comes back to you and says, for 2 years, you haven't done anything. Why? And you give an explanation. To some, they even come after 20 years, and you see that this person who has never done anything for the last 20 years, and there are some older beneficiaries who can run the estate, why don't you give the estate to other administrators to manage it? So to answer your question, yes, we consider very seriously inventories in administration of the estate. Thank you.
Thank you very much. Maybe to even add on what she has stated, if you are buying now land that is being administered, and especially if you are buying from a beneficiary, part of your due diligence should be to ascertain actually what was given to this beneficiary. And the only documentation you can have is the inventory and the final accounts. It's not that a beneficiary, because you see they can sell anything, any part of the estate, and you might be in trouble if you don't carry out that due diligence. So if you are now buying from an administrator, by the way, the law now requires all the beneficiaries to consent to that transaction. So part of your due diligence is to find out who are the beneficiaries who are declared when the petition was done. That is a statutory requirement. But if somebody is going to say, this was my share that was given to me, again, do your due diligence from the file, ascertain from the final accounts what actually was given to this beneficiary. So we are going to stretch the definition of a bona fide purchaser for value, especially if you are buying from an estate, to include that due diligence as well. But yes, we are very strict. It's a statutory provision. You must have an inventory within 6 months, final accounts within 1 year. And now the letters of administrations actually lapse after 2 years. Because we think that, administrators should not be there perpetually. The only exception is if there are minors, say, in the estate still benefiting from some of the properties. You have to ensure that they are educated until their age of maturity. That's the residual role you can play as an administrator. But this, in the past, administrators would be there forever. Now, Justice Wolayo, I did not get the first part of your question, but yes, every mediation settlement should translate into a consent judgment. And that's the assurance we usually give to the parties. The parties usually believe that when they come before you as a mediator, it's just a gamble. How do we enforce this arrangement? So the assurance we give them is that once they reach an agreement, it should translate into a consent judgment, a consent decree, which can be executed. Of course, there are serious problems with executions in the family division. If we have been given a responsibility and in the course of the way you fail, you are a father, you have been told to pay so much for fees, and then you're out of a job, and it comes to execution, what happens? Do we send this man to prison? Because most of the applications actually are either contempt proceedings or execution. So even up to that point, there are still mediations going on. How do we manage this? Because we don't want to send this man to prison. You know, when he goes to prison, what will happen thereafter? You must appreciate even at that point why somebody is not fulfilling his or her obligations. Now, with regard, I heard you say remedy. A remedy is usually worked out by the parties. The petition is exhausted. Because if you are looking at issues, say, of separation, of child custody, of sharing of the matrimonial property, all that would have come out. It's like a judgment that is settled at that point. So there is finality, and that's what we usually tell people, so that they are not worried that, somebody can breach the settlement and then move on. Rachel Doy, there are no separate rights now for a widow and a widower. Like the children, the rights apply equally. Okay? So if in an arrangement it's the widow who left a residential holding, the same rights will apply to the widower. Okay? So it is we no longer have that discrimination at all in the new dispensation. So whatever applies to the widower will apply to the widow. The same with children. Like the Baganda say, there is no vana or ebyana, they are all children.
Thank you very much. We shall take our final set of questions First is Mr. Max Mutavingwa, Mrs. Robina Shonubi. Oh, sorry. You want to? Just a minute. You'll answer. We shall have Mr. Max Mutavingwa, Mrs. Robina Shonubi, Justice Kasule, Justice Tadeo Asimwe. One final question. Is somebody? The person, yes, I see your hand, but I can't see your face. You'll be the final person. But before that, let's have Dr. Tim respond to something.
Thank you so much, my Lord. I would start with Madam Rachel, who also asks about the dichotomy between international law and customary law in light of the international and regional instruments, that debate. Yes, we have our customs, but we shall also acknowledge or remember that even our own constitution has subjected our customs to positive customary practices in Article 2.2. So even when you read that in line with the international and regional instruments, they also uphold positive cultural practices. So it's important. I think we can still apply international and regional law. For instance, if you look at the African Charter on women and people's, the protocol to the African Charter on Women and People's Rights, they have a resolution on property interests in marriage, during marriage, and at its dissolution, and no spouse should be disenfranchised of their interests. So it's important to see our judiciary also citing those. And remember, we have a state reporting obligation. When we do our state reporting before these regional or treaty bodies, we must demonstrate that Uganda has not only ratified this instrument, but is actually enjoining them or enforcing them in their legislation, court jurisprudence, and programs of the state. And we are at liberty as a wise court to also apply them to the extent that they apply in our context. Because if you look at what His Lordship raised earlier, the definition of marriage in Uganda, it may be different from how US defines its marriage. But the law has also accepted, the international instrument has also said every state must define a family and marriage according to its context. You see? So it gives room for state sovereignty and application of international and regional instruments within the context of a particular state. And before I leave that point, just go back and reflect on the decision, the Justice Arachamoko Barrio decision. And you see how custom was playing, but even the justice said custom transforms and moves, and we should breathe life in the constitution, in the international instruments, and give the right to her preferred place of burial place was then recognized after infusing all those laws. So we can go back and read that decision and appreciate. Then I thank the AG also, the Administrator General, for the additions to the history of legislation, and then arriving at the question of the intermingling between matrimonial property and principal residential home. You see, we have, when we meet litigants, when we meet other people in other circles, they say, then it's better off to be a cohabitee, because a married person at death, when one spouse dies, you lose then everything, because even if the principal residential holding remains, if you should remarry, so you're in some kind of prison. If I remarry, I lose every indirect and direct contribution I ever made to this property. So I must stay in this home. So we must think, when you look at Kenya and the UK, I try to read what is there in the broader report. They distribute the net estate of the deceased spouse after deducing the contribution of a surviving spouse. So maybe we need to think about that. We go back to the Ambayo decision. Ambayo, it's a Supreme Court decision versus Jacqueline Aseru. We go back to Rabinumi, those definitions, and the recognition of direct and indirect contribution, and then how do we deal with our own situation at the point of death, and if we are not talking of matrimonial property distributions. Then I would like to just substantiate on what His Lordship said, the due diligence required of a purchaser now. It has been made, actually what you said is restated in the Supreme Court decisions of Israel Lwanga, Mubiru, and others, and also Philip Dumba. The Supreme Court has gone ahead to even expand and say, with fraud, if you've not sought the consent of the spouse and the beneficiaries of the estate, then you cannot hide under the bona fide purchaser for value. So the other courts can just, using our rule of precedence, then apply that. And then finally, when we talk psychosocial support, because of the nature of these cases, I thought it's also a platform that I use to say, let's not forget our litigants with disabilities. They would also need support, so the court must provide room for litigants with disabilities. In terms of infrastructure, it's okay now, there are lifts, there are ramps, but how about sign language? How about those other psychosocial needs a particular litigant might require. That should not be forgotten. Thank you very much.
Thank you very much. We're coming to the end, all the people asking questions, please keep them concise. Mr. Mtavingwa.
Thank you very much, my lord. My name is Maxim Mtavingwa. I'm an advocate of the High Court since 1998. I have heard from many speakers, but my lord, I'm perturbed by the way advocates are being demonized in mediation. In 2013, mediation was made, it was made mandatory in court, but my lord, it failed. But people don't know why mediation failed. And I have an answer. Mediation failed because advocates were edged out, just as simple as that. And as you can see, we are following the same attitude. When speakers say that advocates are a stumbling block, advocates cannot be a stumbling block in mediation. Instead, they are a key. We hold the key to mediation. And I tell you why. You see, we have a constitution in this country, and it provides that a person is entitled to be represented by an advocate of his choice. That's where it starts. We are the people who bring the parties, litigants, to court. We offer legal advice. We trade in services. Actually, our trade, we trade in legal services. Somebody has come to my chambers. I advise him. I do pleadings. Then I'm coming now before you as a mediator. But I heard from one speaker, even an advocate is not supposed to sit on the high table. Why? You start pushing me out. Now I liken it like this one. It is like your maid is at home. A maid has cooked food and has served, then at the time of eating, you push her away. But she's the one who has cooked the food. She can kill you even. She holds the key. So advocates, we hold a key in mediation, and I'm telling you, our clients believe in us. When somebody goes to an advocate, he believes in that advocate. We can prevail upon our advocates. We are the ones to tell them, this case is settlable, this case is not settlable. Let's go to the Supreme Court. So let me tell you, ladies and gentlemen, if you keep on edging out advocates, you will come to naught in mediation, as it was in 2013. So you should note that one. Advocates, we are the ones now with the key. Actually, we should hold a conference of the advocates. All of us, we should be made part in mediation. Then we should be taught. The seminar should be handled as Justice Bed has said already. Because he was an advocate. You see, people who are advocates, they have a different approach. Because when you are there, and if you have not been there, you cannot know what happens there.
Okay, Mr. Mtavingwa, we've got the point. No, one question. Let's allow others to ask questions.
I have another leg, my lord. Maybe I'll bring it later.
Yes, later.
Yes, my lord. Thank you very much, my lord.
Mrs. Shonubi.
Thank you very much, my lord. I just wanted to commend the Administrator General's office, the state attorneys, because in the past 30 days, I've had 2 separate families mediating matters that concern administrators. And as we were generating the clauses for the consent judgment, you found that it occurred to them that this is an inventory. Then I'm like, oh, really? And because I wasn't really conversant with the 6 months and all that. So the parties actually updated me and said, we are just going to attach this consent when we file our inventory, because it has the distribution of the properties, it has the beneficiaries. So I think the Administrator General's office is actually telling these administrators properly. The only thing I do differently maybe is when we're in midway in the session, as I'm getting to know the parties, I sometimes ask the lawyers to explain the duties of an administrator when they're saying, we don't want this one, we want that one. And so when they explain
what an administrator is, what their roles are, then they sort of understand that this might be the best person. Another thing is that with the lawyers, somebody said that they're stumbling blocks, and somebody saying they're the key, and I always thought mediation was self-determination of the parties. So I just want to say the way I handle my mediations, I don't walk in like a judge when everybody is seated. I'm normally sitting before the parties enter. So it is upon me to say, no, you sit over there, you sit over there very nicely, and the lawyers go and sit where I've asked them to sit, and it's normally on the second row. It's just the way I've done it, and no one has ever opposed it. And then automatically the parties realize that they're being empowered, and you tell them, yes, we'd like to hear from you, because it's your matter. This is your opportunity to speak. And they embrace it. And I involve the lawyers by asking them questions that people don't seem to be understanding, and we flow very well. So I think that the only time when I found a lawyer was a bit upset was when, because we were now reading through the clauses, then one of the beneficiaries said, I've withdrawn all the other cases that my lawyer is handling because I think we've solved them. You know, everything has collapsed because of this successful mediation. And when they left, the lawyer came and told me, but what about this part? I said, the man has withdrawn everything, no revocation, everything is over. And he left, but he knew that the parties are determining their own life, their own destiny, their own inheritance. And so, yes, the previous speaker may think that they hold the key and all this, but actually you'll be very impressed with your parties or your clients, that they actually know what they want. They actually know who is who in their families. And they can do very, very nicely if you sort of respect them and charge them to continue. Thank you.
Thank you. Justice Kasuli.
Thank you, Chair. First, I just want to make an appeal to the judiciary, particularly their lordships and their worships, on the issue of inventory. When an inventory is made, the court should do, and I am requesting that it goes an extra step and ensure that when this inventory is filed, first and foremost, that the same is filed within the stipulated period of 6 months. If it is not filed, the record of the court should show, and the parties should be called upon, why the inventory is not filed. When the inventory is filed, again, the parties to the estate should be able to be called, and they express themselves on what has been filed. That will ensure that justice is made, and those, particularly the beneficiaries, particularly those who cannot speak for themselves or speak through other voices, can inform the court of the exact position. A lot of damage sometimes and fraud is carried on because in our common parlance, once one is appointed an administrator, then one assumes that all the properties of the estate belong to him or her, and then they deal with the same regardless of any positive accountability. So I'm appealing to the court system that more stress is put on this so that justice is done. Lastly, the whole regime of alternative dispute resolution, all of us are giving it prominence now, and because of its essentiality to rendering justice to society. In a way, there may be some blame here and there. And I think the attitude should not be that, oh, why are we in the private practice being pointed out as being a stumbling block. Whatever we are, whether in private practice or otherwise, let us take the opportunity to see to it that we adopt those positive steps that can facilitate, that do facilitate and ensure that the whole regime of ADR operates well and renders better justice to our society. Thank you, Chair.
Thank you very much, Mr. Justice Kasuli. Justice Tadeo Wasimwe, please keep it concise.
Thank you so much, my Lord Chair. I was just about to stop when Justice Kasule put his remark, because my point is precisely on what he has said, but I would like to add that would want to hear from the family division on this issue. It's a big elephant of an inventory in the judiciary for reasons that once a grant is given, 80% of those grants are never followed up. Isn't it high time that, since the succession law now puts a limitation as to the period in which administration should go on, that isn't it high time now that as judiciary we should assign specific roles? Is it the judge who has granted? Is it the registrar? So that the roles are clear. And then we also, I would like also to hear, is there a remedy for this grantee who slips for the 2 years? That is one. Two, is there a remedy for this person who has wasted away the estate? Do you have to wait for a petition to be filed by a beneficiary so as to grant these remedies? Or as a judge or as a court, if you find within this period of 2 years, this person has wasted away the estate, do you have to wait for a petition from a beneficiary? Or you can read this inventory or peruse the file and find no inventory, and as a judicial officer, you are capable of passing on this remedy. And finally, is there an exception to this period? If the 2 years go and I have reasons, justifiable reasons, as to why I have not administered the estate, is court's hands tied by the succession law, or there are exceptions to the limitation? Thank you.
Thank you very much, Justice Tadeo Wasimwe. We shall have the question from the corner, the other side, and then we shall get responses. Please go ahead. The gentleman in the corner. Okay.
Thank you very much, my lady. One is a question going to the family court. Have you had a situation where a widow, at the same time an administrator, the deceased husband unfortunately mortgaged the matrimonial home without her consent? He actually saw an affidavit that he was single, but he had children. So now the man has gone, and the lady is suing the bank that she wants her title back. The bank wants to sell because the loan is long overdue. Should she argue her case as a widow or as an administrator, considering that an administrator inherits both assets and obligations? Second one is about lawyers. I haven't had a problem with lawyers. About 95% of my cases, lawyers have been cooperative. Reason being that at the time I'm holding preliminary meetings, I set out rules of engagement, and they know their role is either to represent the client when he's not there, or negotiate on their behalf if they have written authorization, or just keep seated with them, prompting them with facts and dates and numbers. And I have had almost 100% success with the lawyers.
Okay, thank you very much.
Thank you.
So we have had comments. Just one question from Justice Tadeo Asimwe. Mr. Mtavingwa, I think Justice Kasule has ably addressed your concerns. We shall have His Lordship, Keitirima, answer the question on the floor.
Okay, thank you. To comment briefly on Max Mtavingwa, my experience in the last week is that you must have a buy-in of the advocates. If you don't have a buy-in, it will be difficult to settle that matter. And it's actually important to have a caucus with the advocates to prevail over them, especially if there are unreasonable demands from one side. I usually find them, they can easily persuade their clients to buy in. So it's important that they are on board, but of course not to say that there are some who come with the mindset that, you know, we shall meet in court and we have a very good case. Those ones are also there. My Lord Justice Kasule, the practice now in the family division is that when you're applying for even an extension to file an inventory, first of all, it must come in form of an application. You must give reasons why you never filed within the statutory time. And we always insist that the respondents must be the beneficiaries of that estate. You know, we make it more transparent as that, so that they know what is going on, what the administrators are doing, and they're on board. Justice Tadeo, it is now a ground, actually, under the new Succession Act. You can apply to revoke letters of administration if the administrator has not filed an inventory within the required statutory time. So a beneficiary can bring a petition to revoke those letters of administration. It is now even a criminal offense under the Succession Act. There are criminal offenses that have been created. If an administrator mismanages an estate, they might find themselves being charged in a criminal court. It's not that it's because we have not invoked these provisions, but we want to have a discussion with the DPP to see what role she can play, even the Administrator General himself, to start charging these people, because there are people who really go and mismanage an estate as if it's their personal. Even when it's your personal property, you don't mismanage it the way these people at times do. So, with regard to matrimonial property, yes, there's that definition in the Mortgage Act. And I think the banks have to do some due diligence before these homes are mortgaged. I know the practice is that at times even people take photographs with fictitious women. They go to the house, they pose as if all men. They pose, they get that spousal consent. And at times, by the way, it's by collusion. It's by collusion. These people know what they are doing. So, I don't know. And that's why I think this registration of marriages is very important. It's not about the pictures. These marriages are supposed to be registered if they are formal. So part of the due diligence the bank has to do, I think, is to still go and find out, yes, is this the person who posed with this man actually the wife? Was this marriage registered? That would be the best way the bank should do. Otherwise, if it is established that you mortgaged matrimonial property and that fact is proved, the bank will lose. Okay? Because it's mandatory that you get that spousal consent. Extension of time, yes. As I've said, they are residual. Now the letters of administration have a duration, 2 years. But there could be some residual roles the administrator plays. As I've said, for example, if the deceased left young children, because even in the law, we are supposed to identify 20% of the estate. that should be taken out to look after these children. When you are distributing, and say there is a commercial building, you take that out for purposes of looking after these children or people with disability. So there are those residual roles the administrator plays. Or if they are matters in court, for example, which have not been concluded. So you must bring out those grounds. If you convince the court, then the letters will be extended. Thank you.
And to add to what Justice Keichima has said, the security that the beneficiaries could have upon filing an upon applying for letters of administration is the administration bond. And this we always advise that when the beneficiaries and the petitioner are filing for this, applying for letters of administration, they should avoid underestimating the estate. Some say the value of the estate is 50 million, meaning 10% is 5 million. And yet the value of the estate could be 5 billion or 6 billion. What does that mean? In case of default, administration bond will step in for you. That is the first remedy you have to gain from the executors, to gain from the administrators. So that is key number one. My Lord Justice Tadeo, you wanted to find out about following the letters, 80%. These letters are followed directly or indirectly in so many ways. Ministry of Lands normally, lately, contacts the family division to find out whether they are genuine. And that's a trigger. They find out, and when we reply to say, yes, they're authentic, but no inventory, so you will not proceed. That's a stumbling block for you. Same applies to banks. Before they give a mortgage or any loan, they contact the family division. We pull out the files and we say, no inventory. Yes, the letters could be authentic, but no inventory. And any transaction that you're going to have on these letters, you'll have to come back to the family division to ascertain whether the inventory has been filed. So inventory filing is very key. Thank you.
Okay, thank you very much. Now we have our final set of questions. We shall have Justice Jean Rakakoko, Winfred Adukule, I hope I've pronounced it right, and finally Her Worship Sarah Langasio.
Thank you very much, my Lord Chair. This is in relation to mediation settlements, and then I think it was Justice Wolayo who talked about the consent judgments that come from that. We notice that sometimes, first of all, as a division, we encourage and we put mediation or ADR as the starting point of how we settle our matters. So, but lately we've noticed that this mediation is in some instances used as a way of it's fraud. And how is it fraud? If you notice in most of the mother files, the administration cause files, these families have numerous beneficiaries. So you find a family of 10 to 20 beneficiaries. At some point, 2 of the beneficiaries come to court, file a matter in court, this against the administrators or the executors, and then this filed case is sent to mediation. Now, they go through the whole process of mediation, and then they settle with the administrators, and then in many instances, they distribute. Now, where the interplay of these mediation settlements needing to have the court order is now when they come to ask for sanctioning, you find that these 2 parties who have gone to great lengths to settle this matter in mediation are actually just 2 out of 20. And in their mediation settlements, they have actually distributed properties that should not have been distributed just amongst the 2. So I think as a court, we've decided that we must go the extra mile. Even when you've gone through the whole mediation process, it's important that the lawyers make sure that the consent judgment reflects the true position of what the mother file, which is the administration cause file, is about. So let's not try and just rush and get these matters mediated. We have to make sure that the effect of the mediation is for the good of the entire family or the entire state.
Thank you. Winifred?
Thank you very much, Madam Chair. Mine is a comment, but perhaps also food for thought. This morning we're talking about custody issues, maintenance, and inheritance for children. The one set of children we're not talking about child offenders. When these children offend, they do not only impact the family, but also the wider community. If we're taking this conversation of ADR forward, is there an opportunity for us to expound and include juvenile offenders in this conversation? Experience has shown when we first had one with Justice Kwesiga, we're not saying children should not do time for the crime, but what we're saying is when time comes for them to be resettled into their families, is the community ready to receive them? I hope after the 2 days we're able to have a roadmap on how to deal with child offenders. Thank you very much.
Thank you very much. And finally, Her Worship, the Chief Registrar.
Thank you, Chair. First, I wanted to give some information for purposes of persons who have been concerned about payment of mediators, just so that it is clear to everybody, because previously we've not had structured rates, but now we do have rates for mediators. So, Council Anne, I guess this should be interesting you, that we have rates for mediation in the superior courts, that is High Court, Court of Appeal, and the Supreme Court, both for a successful, partial, and unsuccessful mediation. For successful, it is 300,000 per case, partial 200,000, and unsuccessful is 100,000. Those are the rates we are working with right now in light of the resources the judiciary has. And then in the magistrates' courts, a successful mediation is 150,000 shillings, partial 112,500,000, and unsuccessful is 75,000. So the days of discretion of where you paid 50 here, 100 there, those are long gone. These are the rates that are currently guiding mediation. So I think that makes it clear for the mediators and those intending. Number two, the question goes to Honorable Justice Keitrima. You tickled my mind when you talked about, when you recommended schools to prepare young people for marriage. And I thought as we wait for those schools, how about we start empowering the structures that are there in the churches, in the cultural institutions, the mothers' union, the fathers' union, the marriage counselors, they are there and we are here. But we can start there so that they are fully empowered, because everyday marriages are happening in hundreds in this country. So let's consider these structures and work with them. And then lastly, I couldn't agree more with you on the issue of the need to manage the exit well. I think many of us have witnessed very ugly scenes in weddings. You were talking about you will finally meet in weddings. Allow me to just say one wedding I attended recently. Everything was glorious until speeches started. A separation, I think, of about 30 years played very ugly there, with the mother saying, you know what, this man's role, you see him, is the father. His role was only to put this boy in me. After that, he became totally useless. And the man almost disappeared in the chair. And it was really bad. So what I'm saying is that how we help people manage the exit is really, really important. I've seen relatives guarding churches, taking charge of the gate. So, my Lord, thank you so much.
And on that very happy note, if there are any final remarks from His Lordship, the DCJ, okay. So thank you very much.
Thank you, and thank you so much, my Lord, the Chair. Let us give a big round of applause to the Chair. A long and very engaging session. Another one for our panelists. They have really done us well. So we are now going for our lunch, and we are going to the venues where we had our breakfast. So if you are at level 7, please go to level 7. If you are at level 6, you go there. Let's have lunch. Our time is a bit reduced, but not because of the chair. There were some delays in getting lunch ready. 2 o'clock we should be here because there is a session before we have the Honorable Chief Justice of Kenya. There's that session that must start at 2, so I request that we go there. May God bless our food in Jesus' name. Amen.
At least they know how to get away with it. Only if I can drive yours. What do you want to drive?
discussion. Morning. Our topic for discussion.
Protocol officers kindly get their lordships and other members to convene, and we start the afternoon session. Your worships at the Secretariat, sorry, I might have to cut your lunch short to go and help in ensuring that their lordships and the other members convene for the afternoon session. We are 10 minutes late. Worship Jackie, kindly help me reach the protocol officers at level 6 to encourage their worships to come, and then we proceed with the session. Protocol officers, Worship Faisal, kindly help us in ensuring that their lordships attend on time. My Lord, the Honorable, the Deputy Chief Justice, my Lords and your worships and all other invited guests, good afternoon and welcome back from that short lunch break. Allow me, my Lord, the Honorable, the Deputy Chief Justice, to welcome the session chair, Honorable Lady Justice Helen Obura, to take us through the next session. My Lord, you're most welcome. Members, I request you to take your seats. Members, I request you to take your seats. My Lord, you're welcome.
Thank you. My Lord, the Deputy Chief Justice, permit me to adopt the protocol that was well established in the morning. This session has two topics that we are looking at. I would like to invite the presenters to take their seats. I invite Mr. Charles Kasibayo, the Administrator General, to step forward, and Dr. Henry Honoria, please, plus the other two presenters, Rogers, Twesije, and her worship, Prosi Katushabe. Please join me here, and we begin because we have only 30 minutes within which to do the presentations. Dr. Noria, please take my left seat. I'm going to apportion the time as follows. The Administrator General, who is going to start the presentation, will take 10 minutes. Dr. Honoria, my classmate at the Law Development Center, will take 10 minutes. And the balance of the 10 minutes will be shared by her worship and Mr. Twesije. To me, to sit here between these two gentlemen is like homecoming for me, because I first worked in the Administrator General's department when I joined the Ministry of Justice and Constitutional Affairs. And as I said earlier, I was with Mr. Honoria, who was actually, I don't know whether he was not on top of our class. So you can guess, if you went through LDC, you can guess how useful he was to many of us. So it's my pleasure this afternoon to invite them to speak to us. I know it's a difficult time because we have just had lunch, but in case you want to doze off, remember that this session relates to our permanent exit from Earth here to go and meet our Maker. So in case you want to doze off, just remember that you need to be attentive because we are all candidates. We are just waiting for the appointed day. So thank you so much. Let me invite the Administrator General to kickstart the presentation for this session on the topic, estate planning in Uganda, adopting ADR as a best practice in the management of estates. You're welcome. Put your hands together as he comes to present.
Thank you, my Lord, the Chair. Protocol has been established. I will proceed to presenting this topic within 10 minutes. Estate planning in Uganda, adopting ADR as the best practice in management of estates. Of course, you are aware the law governing this stems from the Constitution, Article 247, the Succession Act, now CAP 268, Administrator General's Act, Missing Persons Act, and the Mental Health Act. Of course, an estate is an aggregate of all property of the deceased person, including shares or expectant incomes from pension, and the succession processes, of course, involve two broad categories, which is testate and intestate succession. And as my chair has put it, human beings are not immortal. Thus, their wealth must be carefully planned, and hard-earned wealth can vanish if not well planned for the benefit of the deceased's beneficiaries. Intergenerational transfer, wealth transfer, is an old concept. It is biblical, with origins in Numbers 27:8 to 11, and Proverbs 13:22. A good man leaves an inheritance for his children's children. So that involves planning. Of course, there are many tools of estate planning or succession planning. These include probate and non-probate. Of course, for probate arises from a valid will, and therefore this is where the challenges start. His Lordship Kaitirima feared a question. He wanted to do census here. How many people have wills? If we ask the same question, I don't think you people will even raise your hands, because there is a myth that when you make a will, you die. I don't think that is true. So I also declined to make this census, but the problems start from fear of making a will. Yet we take a lot of time accumulating property, but when it comes to its planning of who takes what, and we shy away. I will not go to the definitions of a will, but I must implore you to look at the new law on the validity of wills. There has been a few check on testamentary discretion, that, for example, residential holding cannot be disposed in a will, and the requirement that every page of the will must be signed by the two witnesses and the testator, and they should put their addresses on each page to avoid fraud. I've already put what is restricted from being disposed in a will. So that is a major, major, major estate planning tool, because you determine who will execute your will. You don't leave it at the discretion of the beneficiaries with the input of Administrator General and court. You are able to carefully decide who will implement or execute your will. So this gives you an opportunity to exercise your testamentary freedoms of who takes what. Therefore, a will is an important tool of estate planning. Unlike when a person dies without a will, where the dictates of law come in to play the role that you would have done when you are still living. Now, we have been trying to establish how many people in Uganda die tested, how many people leave wills through my office, and also some consultations in court, because some people have, when you make a will and name executors, and they don't decline or they don't die before you, because there is a possibility that they can predecease the testator. There is an estimation, this would be for your discussion, that the percentage is only 15%. Around 80%, no will. And the Baganda say, afanga taramye, warumbe yabgava. So you can see where the challenges are starting in avoiding succession planning or estate planning by making your will. Of course, when you make this will, it avoids the expensive litigation, it bureaucracies associated with several meetings and disagreements in the Office of Administrator General, and issues of determination of DNA now. If you have made your will and say Charles Kasibayo is your son, I don't think it's anybody's business to go and apply for paternity determination. When I said it some times back, lawyers reacted and said it seems the Administrator General is also illegitimate. And I laughed so hard that my wife had me laughing so hard in the sitting room. And when I told her, she said, "I told you, you resemble your uncle." So this goes to what that video we saw. It is exactly, the man was like 70%, they want to do a DNA. So when you make your will valid and name your children, it would be nobody's business to, even if you are disqualified. But why? What is the cause of action? The exercise of testamentary discretion would be at play. Of course, trusts are not very common in Uganda, but we can embrace them. This can be testamentary trusts or trusts created during your lifetime, and say, because even land, God stopped creating land, so it is not expanding. So you can create trusts during your lifetime and decide how that, make a constitution. There is a procedure. You make a trust deed, register it with URSB, then lands, and determine how your affairs will be handled, who will benefit from what during your lifetime. Gifts, of course, these can be made during your lifetime. You don't need to wait in order to give out your property. If you have not stolen it and you are confident, you can pass it to your children or your intended beneficiaries during your time. There is a gift provided in the law that you can make on immovable properties within 6 months if you are sick. But if you recover, then it reverts back to you. A gift when you are contemplating death is only actualized if you die within 6 months. And that is for movable property only. So if you say, my car is for Justice Helen, if you don't die within 6 months, it reverts back. These gifts are common and they are used in our inheritance, only that they are never written, and we have been discussing with Justice Kaitrima about this, because there is a practice in our communities. When a man grows and marries, they cut a piece of land and say, this is your property. He begins his business, and another one to that extent. But there is a practice when a person dies, these people who are given those gifts wants to come and fight for the residue, which is an injustice, unequitable. It is something that we have to consider from our own practices, and maybe write wills and say so and so was given a piece of land. Another non-probate method is forming a company and allotting shares to your children. This one you will see how they are performing, and it will not be a subject of inheritance. What would be a subject of inheritance will be that which you leave in your name, or your name, your percentage of shares. The others would have moved. Co-ownership of property. If you have your wife, for example, and you think she should take a certain property, you register it as joint tenancy. It means the survivor takes it. Common law principles are that if you die with your wife at the same time, the law presumes that your wife died last. So so if you die in Mavera Forest and nobody was there to witness, your wife would have died last, and therefore the beneficiaries to your wife would take the property. ADR as emerging best practice for management of estates. I've already put it that there is an estimation of around 85% of people dying without leaving wills. And therefore, the video which Dr. Patricia played tells the scenario now. Determination of parentage, determination of... I've been warned to wind up this paper. Of course, this calls for mediation, that people have not left wills. We are currently opening 5,000 files. Previously, we were only opening 3,000. Now they have increased to 5,000. All of them have issues. So there is need to talk to these people, educate them about the law, and mediation is the best way of practice. Now there are issues of new litigation. We are now litigating about determination of burial grounds. Issues are raising letters of administration or probate. So all these call for people to be mediated, negotiated in the Office of Administrator General, so that they understand that it is both a legal but also a customary matter of determination of where to bury a person. I have already said during my supplementary of Dr. Patricia that even when these Wazungu came here, they avoided the strict application of the law of the ordinance of 1906, well aware that our customs, there is a conflict, there is a contestation between the customary practices and the law, now allowing a female to be a hairless. Some people might not easily take it that a woman can now be hairless and preside over customary function. When Charles Kasivayo is marrying, a lady would be there to preside. So there is that kind of conflict of the law and the customs, and so there is need for harmonizing them and talking to people that, for example, I've been to church and I said now when a widow remarries after the death of the husband, she is entitled, according to the new succession law, to come back and share, partake the 20%, even when she has remarried. The reasoning of the law is very clear that she accumulated her share during the subsistence of marriage, and therefore a death should not disinherit her or deny her to enjoy other rights of marriage. But nobody seems to understand this. They think it's improper. So, so these matters require careful mediation and talking to people. I'm concluding, my Lord. There is a need, of course, to facilitate effective alternative dispute resolution by training officers. You have to train these people to be very patient when they are negotiating family issues. If they are not, then they will escalate them into adversarial nature of settlement. Training agents. We have agents who are chief administrative officers, but they are not trained. Town clerks. We can now, under the Administrator General's Act, even appoint more agents. I have heard Honorable our Minister, Norbert Mao, mediate one meeting, though unsuccessfully, in the Office of Administrator General, so we can have more judges other than see the same faces all the time. We can have more judges in the Office of Administrator General. We can have more advocates. We can have Council Mtabingwa come and mediate, but in a calm way. If you use any force, you'll not get I'm concluding. Of course, we will need financial support for these agents to move and even mediate in the homes of deceased persons. And of course, the new laws have come in, like residential and the principal residential holding, who remains there, who is entitled. All those issues are new and people are not aware. So there is a need to talk to them before and educate the new administrators about the disposal of property, requiring consents, etc. I thank you.
Thank you so much for the presentation. One of the highlights, key highlights, is that you need to plan by making a will. But I'm saying if you fail to make a will, you are also planning, but you are planning for confusion and chaos in your family after you are gone. So I think we need to take that seriously. I have fears about the gift that you give for 6 months. I suspect that in Uganda they can help you to die within the 6 months. So as to... for the next segment of our presentation, we have 3 presenters who are going to give us a research finding, and the topic is impact of technology and pandemics on estates planning in advancing the significance of alternative dispute resolution. We have 3 presenters. This research was commissioned by Center for Public Interest Litigation in conjunction with the Family Division of the High Court of Uganda. And to kickstart that segment of presentation, we'll have Mr. Rogers Tracy presenting for 5 minutes, followed by Her Worship, who will also use 5 minutes, and the conclusion will be made by Dr. Honoria for 10 minutes, although our time is reducing so fast. So please, you're welcome. You could use the podium.
Thank you so much. If we can have the presentation, I have only 5 minutes, so I will try to be within the time, precise and brief. Just briefly, like the chair, so our Lord said that my name is Rogers Tracy. I'm not really a legal person, but I support government and non-government organizations with research. So my profession is in research and evaluation as an advisor. And I was lucky that 2 years ago, I worked with Center of Public Interest Law plus Family Division during the COVID times, where they were interested in trying to understand estate planning, especially in terms of uncertain times. So unlike what we have on the schedule, we're actually building on to what the previous speaker has been talking about. So I'll present what actually we did, and my colleague will present the findings after that. And like I said, we were interested in trying to understand estate planning, especially in times of which are very uncertain. And if you all remember back in 2020, 2021, these are the times of COVID. And so when I was approached by the CPL and Family Division, we wanted to know what was going on, because a number of things were happening at that time. A lot of questions were going around, especially people asking themselves things about what if, especially during the second wave of COVID in 2021. And so we thought, or the team thought it was very key to investigate the preparedness of the population by looking at different files within the Family Division at the time. So I think it's obvious why we chose Family Division as a case study, especially in terms of the scope of work that it does. But also, at that time, there was also the amendment to the succession law, and so it was a good time to understand and see how this can be informed much better. And like we said, the background is basically about, at that time, there were so many people asking about themselves. COVID came very fast, people were dying very fast, and everyone was asking themselves, what happens if this happens? And that's what we actually based on to try to review some of these things that were going on at that time. And like I said, the objective was basically to understand the impact of COVID-19 on succession law, especially in terms of administration of estates, by looking at filings and litigations, which were with the Family Division at the time. And we hope that by looking at this, we're able to explore and provide strategy that can inform better estate planning for the population. But you can only be able to provide better planning and recommendations if we understood the status quo. And I think the previous speaker has talked about a bit of that in terms of how many people have a will and all that. And that's some of the things that we are looking at. If you look at the research questions, we're basically very interested in how many people actually die with a will or not. And we also looked at the duration it takes to file, especially after death. We looked at how many people were able to get their certificates of objections, but also people were being granted letters of administration, and those which were challenged. So these are some of the things that we are looking at, and my colleague will be dwelling them into more of what we found. But like I said, we did a case study with Family Division, and the way we collect the data is that we focused on the period between January 2021 to June 30th, 2022, and we were looking at all those files around that time that were filed within that period. And we were able to look at 2,459 files for a period of 3 weeks, and we did this back in August 2022 with the support of 3 researchers at the Family Division. But we also went ahead and talked to, we consulted with the judicial officials at the judicial office at the time, but also at Family Division, to try to give us more insights on some of what we are seeing from the files. And like I said, we achieved 2,459 files that we looked at, and this was the distribution. So about 675 had been filed between 2021, that is Jan to June. Another 859 had been filed between July and December of 2021, and then 925 had been filed in the first half of 2022. And so this is what we achieved, and I'm happy to present to you some of the findings by Her Worship.
Thank you.
Thank you, Rogers, and hello, the DCJ and the rest. of the participants, protocol observed. I present the findings because the time the research was being done, I was the deputy registrar and I participated in the research. And I would want also to add that most of the things that were found out were actually informed so many changes that happened at family division, with so many papers being put everywhere with explaining what needs to be done at the family division and what needs to change. So the first finding that we got was about the average age of the deceased persons. We discovered that the overall average, and this we discovered from affidavits and certificates of death, the average was 64 years. 18% of the deceased persons were above 81 years. 39% were aged 61 to 81. 34% were aged 41 to 60. And only 9% of the deceased were aged 40 or less. And we also, from that time of the research, we looked at the gender of the deceased persons of the files that we looked at, and we discovered that only 25% were women, and then 75% were men. Yes, that is from that period. I know statistics are alarming, but they should inform us on what we need to do. So the other finding was duration taken after death for the family to apply for letters of administration or probate. So we discovered that people take a very long time before they apply for letters of administration or probate, I think, which also informs the so many disputes on the land. We discovered that 32% took less than a year to apply for letters of administration, and 34% took more than 10 years after the deceased has passed on to come to our courts to get letters of administration. And then 34 is within others. But that shows 34% people not coming to court. You can imagine what is happening in the estate for 10 years before they get the legal document to come. And then another finding was about testate and intestate succession, which is a conversation that has been in this room, and the former speaker said 85% die without making a will. I think you're almost right. We discovered 87% of the people that had applied in those 2,000 files died without a will, and only 13 had made a will. And then we went along to look at the files. After you've been given letters of administration or probate, we have civil suits, what has been challenged. We discovered that only 5% of people who had letters of probate were challenged. 95% of the files where the court had given letters of probate, nobody ever came back to challenge. And then challenging the letters of administration, we noticed that most, if not all, letters of administration were challenged with multiple suits over the years by beneficiaries, by the friend of the deceased. I get that term from Mr. Kasibayo. Friend of the deceased is if you didn't have any title, you're not a legal wife, you're not married, you're cohabiting, any other relationship you had, especially when they are children. So he gave us a term called friend of the deceased, and that is what we use. And we also discovered that there were so many multiple cases, both at the land division, where people are quoting that they have cases in the land division, and they also have cases in the family division. Also discovered that while the letters of administration are not challenged immediately, multiple suits over the years, one beneficiary, another beneficiary, about 15 or after every 3 or 5 years, there was somebody challenging. The number of people who applied for letters of administration, we mean the administrators, the ones that the family chose. We discovered that the minimum is 2, and we had a maximum of 8. But we also discovered that the more the administrators, the more the disputes on the property. It was also discovered that one of the files where the letters of administration had been challenged were 65% were under hearing, 13% were caveated, and 22% for other reasons, maybe failure to follow what, but 65% were under hearing. That means that actually those estates are not being managed or not being used because the cases are in court. We also looked at how long it took to get letters of administration or probate in the family division, and we discovered that 80% got letters of administration within 6 months plus for the family division, and 20% more than 6 months. While it's a plus that we give out letters of administration quickly, they were being challenged also on the other side. Reasons for challenging letters of administration, we discovered most of the time people do not involve the friends of the deceased. As I told you, we got that term from him. You have 10 girlfriends, they have 10 children, they have only picked 2. So every year the other one comes up with a DNA, then the file is called again. Every other year somebody comes. No consent by all family members. Neglect or abandonment of the administrator or executors, where they just abandon the estate. Not filing an inventory was also a common thing, and that informed so many reforms where we came up with the idea that before your letters of administration are certified, you must have filed an inventory. How many administrators had filed inventories? We discovered that only 3% of the administrators had filed inventories, and 97% had not filed inventories. We'd also discovered that 58% had filed after winding up the estate, that is distributing the whole estate, and they come to inform court that they have done their duty. 42% never came back to court, so the court doesn't know what happened to those estates. And those were the findings. Thank you so much for listening to me.
Thank you so much. Could we have the last presenter on that?
Yes, Honorable Deputy Chief Justice, and the protocol has already observed. I have the immeasurable task of addressing some of the recommendations that came out of this study. And as already pointed out, there were a number of findings that came out, and the recommendations are primarily in the context of what we need to do to get people to plan, to do estate planning better. And one of those was sensitization, and I'm glad that in the early days of the amendment to the Act, the family division did a number of sensitizations, conducting training on the amendments, but also, if I remember, there's a template of a will. If you don't know how to prepare one, there's one that has been availed that you can quickly use. But the statistics are alarming in the sense that if you have only 10, 15 or 13% making wills, that means that this is going to continue creating disputes. So the recommendation is, one, can we do massive sensitization on the challenges of intestate estates, and then how do we move this beyond the urban? Because again, one of the things that came out of the statistics is that actually there were certain people who were actually very keen to do estate planning, making wills. If you probably didn't see that when you compared Ugandans and foreigners, there were more foreigners doing wills than us, the locals. But also the making of wills was skewed. It was easier for us in the urban areas to make wills than the people in the rural areas. So we need to take that sensitization so that even those who are not urban-based understand the value of making wills. And then secondly, we need to make sure that sensitization also goes to the administrator's responsibilities. This has been spoken to by the Administrator General, and it's probably one of the things that has been addressed by the amendments. So we need to make sure that those who are tasked, who are involved in administering estates, are provided with this understanding of the obligations, the making of inventories, and therefore this will enable us to avoid these continuous disputes that keep coming back in the courts. The other recommendations are regulatory. How do we strengthen, for instance, security of tenure? And
while the people who are dealing with land in urban settings, it's easier to have titled land. The problem is now how do you deal with protecting proprietary rights in the semi-urban and rural areas where land might be largely held in a customary setting, held as family land, or similar arrangements, and therefore there's a need, how do we create and strengthen those regulatory frameworks, either in terms of regulations, but also making sure that, for instance, certificates of customary tenure are issued, and people are advised to make sure that those are obtained, because at the end of the day, if someone passes on and the land is one that is held under such a tenure, if there's a certificate of ownership under that tenure, then it's easier to understand the demarcations and the scope of the land. Within this, we also found, again from the statistics, the figures that there are very few women compared to men who are taking out, or for whom estates are being, letters of administration are being taken out, may not mean that more men are dying than women. It might have just mean that less women actually have control over property for which then estate management comes through. So one of the things that should be probably is recommended is the need to ensure frameworks, whether regulatory or otherwise, that position women to actually own property, both in the urban as well as the rural areas. And therefore it enables them then to do estate planning and bequeath those estates. And then also judicial making, since we're in a summit involving judges, I think we need to begin also looking at how do we empower women to actually do estate planning and the management of estates after they pass on. This is today is also about alternative dispute resolution. I think this has been mooted or mentioned severally. I found that discussion going on when I came in. Now, one of the things that we are recommending strongly is how do we position ADR in family justice. ADR already is something that has already existed within the judicial decision making for over at least a decade now, since 2013. So it's here. So one of the things that can we strengthen, not just in family justice, but across the board. But since today we're looking at family justice, how do we position ADR to be a mechanism that helps not only decongest the courts, because from looking at it, we didn't do the statistics of what the backlog is, but I'm sure everybody knows the backlog in most of the divisions, but also then to avoid the sometimes contentious and acrimonious nature in which dispute resolution through litigation goes, making it worse even for families. That can we maintain the social cohesion of families by trying to find an alternative way of resolving these disputes? And the number of options here, there are various ADR forms, but I think the Administrator General and most judges are probably happier with the mediation. And I think that it's been the drive that mediation allows in reality. I think for the parties to actually take this resolution in their own spirit and in their own pace, I think our concern most often is that lawyers think that in mediation they're also supposed to participate directly. That's in arbitration. In mediation, you're supposed to take a back seat and let the parties sort out this. Your role is just largely to sort of be there and understand what to do. Now, I think sometimes we put ourselves directly into the mediation, but also I think one of the things that probably needs to be looked at is what kind of, and I have a feeling that the entire spectrum of disputes that arise in family justice, especially in context of estate planning, are capable of being mediated. Whether it's contestation of a will, whether it is the issues about how people have been left out of the will, whether it's about the inventory and the management and distribution of the estate, these are issues that can be resolved. Because at the end of the day, no matter what the situation, these people are part of a family that has been left behind, and the dispute can be addressed within the context of the confines of the law, but also from the necessity to preserve those critical familial relationships. One of the other things that I probably just need to say at the end is the necessity. Sometimes I don't know whether the Administrator General is looking at this. I know it's something we're still trying to work out, and within the judiciary and elsewhere, the role of using evaluative
I think you
mediation.
You should be winding up.
So I'm winding up, and the idea is that let's look at the possibility of, even before these disputes arise, whether this is something that there can be some kind of evaluation of what the parties, the disputes between the parties, and as well bring them to have this resolved as quickly as possible, so that we avoid these delays, where you find someone takes even more years to manage an estate. We can even bring the distribution of an estate and all those before even the 2-year period, if we can have this sorted out and mediated as quickly as possible. So I thank you for listening to the three of us, and we hope that this will be circulated, the report, and then hope that it can be the basis for further interrogation of not only estate planning but mediation in family justice. Thank you.
Thank you so much. Can we give another clap for the three of them? Thank you. I temporarily hand over this to the
Thank you, my
director
Lord.
of the
Thank you, my
programs.
Lord. We are going to proceed to the keynote address, and then the second part of this session will come back when we'll have a plenary later. So allow me, we'll be making a few changes on our seats. I am inviting the moderator who will moderate that session. That is Ms. Barbara Kiley, the country director, IDLO, to take that seat, so that once the keynote is done, you proceed with the moderation. And at this juncture, I invite the Honorable, the Deputy Chief Justice, who is going to introduce the keynote speaker, and then we proceed with the keynote address. My Lord DCJ, you're very most welcome.
As we work on technology, probably I could be doing the introduction. IT. My Lord, you are welcome. I think you are still muted.
Watch yourself, kid.
My Lord, can you hear me?
Yes, we can hear you, my Lord. Probably.
Okay, I think now I'm okay.
Good.
If you can hear me, but I'm not seeing you. I don't know why I'm double on my screen.
My Lord, let me introduce you to our audience. As technology keeps on improving, we hope we shall be here. You will then hear us and see us. Presenting our keynote address this afternoon is the Honorable, the Chief Justice of Kenya, Honorable Justice Martha Koome, who was appointed on 15th May 2021 and assumed office on 21st May 2021 as the Chief Justice of the Republic of Kenya, the President of the Supreme Court of Kenya. She is the first woman Chief Justice of the Kenyan Judiciary, is the Chairperson of the Judicial Service Commission, the National Council on Administration of Justice, the National Council for Law Reporting, and the Vice Chairperson of the Southern and East African Chief Justices Forum. She is also a Fellow of the Chartered Institute of Arbitrators. Prior to her appointment, she was a judge of the Court of Appeal and a judge of the High Court before then. Before joining judicial service, she was a practicing advocate. Honorable Justice Martha Koome was the president of the Kenya Magistrates and Judges Association 2019, member of the AU Committee on the Rights and Welfare of Children 2005 to 2010, chairperson of FIDA Kenya 1997 to 2003, chairperson of the Bill of Rights Subcommittee of the Bomas Constitutional Conference, inaugural treasurer of the East African Law Society, the council member of the Law of Society of Kenya 1994 to 1996. She chaired the NAC Special Task Force on Children Matters that was the architect of the Children Act 2022. She was awarded the runner-up of UN Person of the Year in Kenya 2020, the national honors of the Elder of Order of the Burning Spear, and the Elder of the Order of the Golden Heart, EGH. She is an advocate of the High Court of Kenya, holds a Bachelor's of Laws from the University of Nairobi, postgraduate diploma from the Kenya School of Law, and a Master's of Law from the University of London. My Lord, you are most welcome. We are happy you are with us. Kindly present the keynote address.
Thank you very much, my brother, Deputy Chief Justice of the Republic of Uganda, the Honorable Mr. Justice Richard Butere. Let me also recognize all the honorable judges and the honorable judicial officers and distinguished participants. And ladies and gentlemen, a very good afternoon to you all. Allow me to start by expressing my gratitude to His Lordship, the Chief Justice of the Republic of Uganda, my brother Justice Alphonse Owinendoro, for the honor of inviting me to virtually address this family justice conference on the topic of the role of alternative justice systems, what we call NJS, and alternative dispute resolution in family disputes. The invitation is indeed a testament of the judicial cooperation between the judiciary of Kenya and the judiciary of Uganda, which we deeply celebrate. I thank Your Lordship, the Chief Justice, and the Judiciary of Uganda for organizing the conference, which serves as an ideal platform for a robust conversation and exchange of ideas on how to enhance a people-centered justice, especially in the family justice. Because we do not serve ourselves, we serve the people, and even as we render judicial services, we always ask ourselves whether we are creating harmony within families, whether we are solving problems or we are creating more disunity in the families through court orders. And hence, the need for us to think broadly about the alternative justice systems as a way of building restorative justice in our communities and building harmonies within our families and within our communities. Distinguished judges and magistrates, turning to the subject of my address, the role of alternative justice systems in family justice, I want to offer brief reflections on the central role of NJS and NDL in family justice based on the Kenyan experience. To lay the background, I'll refer to our African societies, where family is seen as a natural and fundamental unit of the society and a critical basis for social order. In other words, if you're doing well in the family, you're protected and your rights are promoted within the family, you feel safe and secure, you are actually empowered to go out and make it in the society. So in our African societies, families give us a sense of belonging, which is a fundamental human desire. Families give us identity, and this makes us feel secure, valued, loved, supported, and accepted, and offers an avenue to share our joys and sorrows. And this is why I really congratulate Uganda for holding this conference to put families where they belong and family disputes where they belong. Like any other facet of our lives, this fundamental unit of our society is at times shaken by an interplay of challenges, including betrayal, death, change in financial situation, work stress, life transmissions, and personal differences. I served in the family division, and I know that is a division where the people who come are at their lowest level. They have either lost their loved ones, their families are not working, they have problems raising their children, so they come for custody issues or maintenance issues. So these challenges often precipitate conflicts that may lead to disputes relating to, among others, separation, divorce, division of property, child custody, or orders for distribution of inheritance that may not really fit within the expectations of the parties who have come before us in court because you do not know as a court how people live. So when you issue an order, like we have a law in Kenya that allows distribution of the estate of the deceased equally among the children, that equal distribution may not bring justice to the parties who live forever together, trying to implement that court order. So when conflicts arise within the family setup, those affected may pursue formal or informal dispute resolution platforms, including courts, NJS, and NDR. We all agree our judiciaries, Kenya included and Uganda, are not the sole forums where justice is found, especially in cases relating to family. We did a research here in Kenya, and we were astounded to know that it's about 15% of the Kenyans who seek formal justice system, who seek justice through the formal justice system. Deputy Chief Justice, you are with us when we had our annual conference on AJS, and I shared my frustrations because I asked myself, what kind of a Chief Justice am I going to be to relate only to 15% of the people with justice needs? So we must open up, and that is what we are calling the multi-door approach to justice, so that people can have many avenues where they can resolve their disputes. Key amongst those multi-door approaches, the one we know about is the adversarial nature of litigation that tends to tear down relationships instead of restoring and nurturing them. Even if families are separating, they need to restore that relationship for the sake of the children. Therefore, in light of the limitation of the court-based litigation, we have found it useful to explore the utility of NJS and NDR as appropriate avenues for resolving family disputes. As you reflect on NJS and NDR as a mechanism of addressing family disputes in your jurisdiction, I would like us to remember that the story of AJS, being a traditional dispute resolution method, is firmly grounded in Africa's rich heritage of communal dispute resolution. And since time immemorial, our communities in the continent have been resolving disputes through processes that were deeply rooted in our cultural fabric. In Kenya, we are lucky that our constitution of 2010, Article 159(2), envisages NJS in that it requires we, the judiciary, to promote NDR mechanisms, including traditional forms of dispute resolution. To this end, the Kenya judiciary has been a champion of NJS and NDR as avenues to improve access to justice and efficiency in dispute resolution. In the post-2010 era, that is before we enacted our constitution, the Kenya judiciary had tried to institutionalize NJS and NDR mechanisms, which we started doing in 2016 and 2017 through a pilot project and we started calling it a court annex mediation program at the family and the commercial divisions of the High Court, only in Nairobi. But we registered tremendous successes made during that pilot phase. The court annex mediation program has since expanded to entail 43 mediation registries across Kenya. And in 2020, we were able to launch the alternative justice system policy to guide the implementation, coordination, and regulation of NJES in Kenya, with the objective of enhancing access to justice, reducing the backlog of cases, and promoting social cohesion. Since 2021, when I became Kenya's Chief Justice, I've been working with the NJES Steering Committee to cascade the NJES policy to the grassroots level in line with the judiciary's blueprint, the social transformation through access to justice, which is the blueprint that is guiding us in the next 10 years. Importantly, we have also established a practice of holding an annual NJES conferences. In June this year, we held the 3rd annual NJES conference at Kabarak University in Nakuru under the theme of accelerating people-centered justice in Kenya, engaging, expanding, and retooling alternative justice systems. And we are glad to have hosted my brother, the Honorable Deputy Chief Justice of Uganda, the Honorable Richard Butere, was one of our keynote speakers. Thank you, my brother, for attending. From experience, like many of you, I can attest that NJES and ADR have multiple benefits that favor enhancement of family justice. The benefits include flexibility, affordability, and effectiveness in provision of justice solutions. I know, like you, we are here in Kenya. In Uganda, you also have a backlog of cases on family matters, and we can't afford to keep families in a state of anxiety, uncertainty, year in, year out. So reliance on NJES and NDR to address family disputes should be based on the understanding that they both provide more amicable, more efficient, more holistic, and more context-sensitive platforms for dispute resolution compared to conventional litigation. For example, many family disputes, such as child custody and maintenance, are suited for effectively resolution through NJES and ADR. This is because at the end of the day, both parties, the parents, must still work together to nurture and take care of the child irrespective of the aftermath of the dispute. So what we normally ask them, what is the end game? What do you want to achieve when you come to court fighting over child maintenance or child custody? And both parents will answer that they want the best interest of the child. And of course, as you engage them, you realize the outcome from the court may not be in the best interests of the child, because the parents must embrace that outcome and run with it without feeling like I was the winner or the loser of the case. Importantly, resolution of family disputes through NJS and ADL also allows parties to the disputes to be agents of their own justice. There is nothing as empowering as a party feeling that they have the agency of deciding their own case and finding the best solution of the matter. In addition, reliance on AJS and ADL is critical to restoration of harmony in families, thereby enhancing peaceful coexistence in our societies. Therefore, AJS and ADL are not just limited to resolution of disputes, but also restoration of relationships and enhancement of harmony. Moreover, it is about communities coming together to address their problems in a manner that is inclusive and respectful of their heritage. We all complain of this justice system that was imposed on us by the colonialists. But 60 years down the line, we cannot blame them, but blame ourselves for not coming up with a system that is responsive to our own needs. So my brother and sister judges, Your Honor, the magistrates, while we appreciate the benefits of AJS and ADL, we should take into account the challenges associated with them, because they are also not just a walk in the park. The challenges include the effectiveness in enforcing the outcomes from the processes. We must be sure that the outcome of the AJS that we are engaging in can be enforced by a court of law, can become a court order. We must also be cautious of the gender injustice, because AJS panels are often male-dominated, despite the fact that many disputes affect women and girls. The likely exclusion of the marginalized and the vulnerable persons who may not find their voices and spaces in those NJS panels, and the lack of accountability procedures for NJS because of absence of proper regulation. So this is why we have taken a lot of time to address these challenges. We must work towards strengthening the capacities of different actors who are involved in AJS and ADL processes. This can be done through trainings which ensure that different actors are equipped with the necessary skills and knowledge. For instance, with respect to NDL, we can ensure that high standards of professionalism are maintained, leading to delivery of quality mediation services. Further challenges facing AJS can be addressed through sensitization and collaboration with grassroots actors, such as the elders, religious leaders, and organized social action groups, to enhance the legitimacy of these dispute resolution processes. When these processes are deemed to be legitimate in the eyes of the communities, if you can be able to eradicate corruption in all its facets in these processes, this will enhance their effectiveness in the resolution of family disputes. Based on our experience in Kenya, NJS and ADL are feasible and legitimate options for resolution of family disputes and enhancement of access to justice in our societies. Therefore, I want to take this opportunity to call upon each one of you in this conference to embrace and support NJS and NDL as important and worthy avenues for dispute resolution, and particularly family disputes. Unless AJS has the support of the judiciary, it cannot survive. Unless we judges and magistrates believe in it, it cannot succeed. I also wish to emphasize that under the Constitution of Kenya, all the rulings or orders from AJS or NDR must pass the test of the Constitution. For instance, we have some NJS panels that are traditional dispute resolution mechanisms which existed long ago, but they existed as male enclaves. They did not include women. Those panels, we have told them they cannot be part of the judiciary-driven AJS because they do not meet the constitutional threshold, which requires the composition of every panel to have representation of women, the youth, persons with disability. So if it's only men, they cannot pass the test. Number two, the decisions that they make must pass the test, the constitutional threshold, the principles of the legality of the order that has been registered. If it is discriminatory against women, of course it can't pass that threshold, therefore it cannot be adopted as the order of the court. In other words, whatever they pass must pass the test and the threshold of the Constitution for it to qualify to be adopted as the order of the court. Number two, it must be with the consent of the parties. The parties must agree to the order that was passed as an order of the alternative justice system processes. So as I conclude, mine is needed to thank again my brother, His Lordship, the Chief Justice of Uganda, and the Deputy Chief Justice of Uganda, and the organizers of this conference for this great invitation. My apologies, I could not make it to grace the occasion physically. Today I was involved in a major exercise of decongesting our remand prisons and also our prison on a two-phase program. First of all, to get the people who are awaiting trial to be admitted to reasonable bail and board terms so that they can do their cases from home instead of overcrowding the prison. And the second phase is where they have been sentenced to a term of less than 3 years and they have served some of it and they have good conduct. They can be admitted to the community service order, which is also an effort towards restorative justice and creating harmony in the society. That is why I was not able to travel to Uganda, my favorite country, my favorite neighbor, to come and be with you during this wonderful conference where we are really tracing the roots of our family and entrenching them and taking care of our families. I thank you all for your attention. God bless you and wishing you great deliberations and great outcomes of this conference, which will make Uganda a better country a peaceful country for families and an example in the region for others to look up to. Thank you very much, and God bless you.
Thank you, my lady, Chief Justice of Kenya, Martha Koome, and thank you to you too, DCJ. My lord, I don't know whether we still have the Chief Justice online. Has she gone? She's online. My lady,
I'm there. I'm there.
My lady, this is Barbara, Country
Yeah.
Director for IDLO. Happy to have you here with us. Maybe as a
Thank
first
you, Barbara. Nice to see you. We rent you to Uganda, so I'm happy you're doing a good job. Proud of you.
Thank you, Madam CJ. I will leave that to my lord, the DCJ, to mention whether my performance is up to task or not. Maybe just as a first question, is if you could unpack for us how the judiciary of Kenya has seen alternative dispute resolution mechanisms and differentiated that from the alternative justice systems. That would be our first question to you.
Say that again, Barbara. Differentiate?
Yes, my lady, if you could differentiate to us how the judiciary views the alternative dispute resolution mechanisms from the alternative justice systems modalities.
Yes, the difference between AJS and ADS. Yes, there is a marked difference between AJS and ADR in the sense that AJS is people-driven, is stakeholder-driven, is need-driven. The communities, and in this case, let me say the court jurisdictions, the court users, we call them the court users committees, are the ones who drive the AJS. And there is absolute agency by the stakeholders in this process, because they form the panels, they are trained on the areas that they can participate in AJS, because there are certain cases that do not go to AJS, especially cases of sexual assault, sexual abuse, even serious cases of violations of human rights, like murder and grievous harm. Those are cases that touch on public policy, law and order, and there are no-go zone for AJS. The other petty offenses, like one I participated in, a child had stolen a gas cylinder. There are small gas cylinders we use in Kenya called Meko. I don't know whether you use them in Uganda. The child had taken the neighbor's Meko, sold it, and bought a mobile phone. So that child was taken to the AJS panel, and the mother, the father, the parents, and the panel sat, and they were remorseful. The parents, of course, refunded the money to buy the Meko gas cooker, and the child was given some work to do for the complainant. It's really dealing with petty infractions, petty conflicts with the law in the criminal justice system. And the police have also been trained on this, and the DPP, they call it diversion. So the NJS is fitting in the diversion, and that is one major difference between it and NDR, because NDR is a complete no-go zone for criminal matters. Then it is inexpensive because you are not paying an arbitrator, an adjudicator. So as we move forward, we have been supporting this as the judiciary, operating it within the judiciary system, where we have, we call it an ukumbi, or a registry for NJS. And therefore now within that jurisdiction of a court where that ukumbi is operating, they come to that ukumbi, cases are registered, we assist them with our staff to register the cases, to make the telephone calls, to call the parties, really facilitate the sittings of the meetings. But there are other areas where those sittings are taking place, because that's one model. There is another model where these sittings are taking place in other venues, like the chief's office. They will convene there, sit, agree, and bring the agreement to the court, and the court will adopt it if it meets the standard that I talked about. So I hope I have answered the question.
Thank you, my lady. Indeed, you have. And just as a follow-on to your last comment on the registration of the outcome from the process, how does the judiciary then guide the different AJS practitioners in ensuring, as you called it, that the outcomes are effective? How do you do the sensitization or the awareness creation?
Barbara, this has been a lot of work of training, and I think you have followed our trainings. The Honorable Deputy Chief Justice also followed during our NJS annual conference that before we launch an AJS forum, they have to go through training as the panel and as the court. They go through a very rigorous training on the do's and the don'ts. The don'ts must be clearly written on the wall, what you cannot do and what you can do. First of all, it's voluntary. The parties agree, let us go to AJS. And we have a form where they sign. Then they record the parties who make the panel, then the deliberations, and then the outcome, and that agreement. This is the one that is taken to court for adoption. Because it's party agreed, it's really an agreement of the parties. You find them actually implementing it without having to be coerced through the normal processes of enforcing a court order. And I can say with confidence that over 90% of them are implemented willingly. Just a small percent where some parties may not agree to the agreement after it has been recorded, but eventually, after they are called by the judge or the magistrate in court, they agree. Another 5% or 6% agree. So it's a very small percent that will end up for normal execution through auctioneers.
Thank you, my lady. At this juncture, if you allow us, we would like to take 2 questions from the floor.
Thank you.
My lords, my ladies, the floor is open for any question that you may have to the Chief Justice of Kenya. Okay. Please proceed.
Thank you, my Lord, for that beautiful and enlightening keynote. My name is Anne Karunji. I'm an advocate in practice. Your Lordship, you well articulated the issue of the principles of legality as enshrined in our Constitution, and or what I will say the test of legality for any order arising out of mediation to get its validity. Now, my question is, regarding the mediation that takes place, let's say, when matters are filed on appeal in the Court of Appeal. And remember that when you're filing an appeal, you have legal questions or questions of law arising from the decision of a lower court or a trial court that you want court to make a pronouncement. Now, how does the mediation process that takes place in the Court of Appeal circumvent those important legal questions or questions of legal importance by having a mediation and getting a decision therefrom? How does it circumvent, and how legal, or how does it pass that test of legality as enshrined in the Constitution? I thank you.
Wow. That's a very complex and very varied question. Thank you very much, Advocate Anne. Questions to do with legal interpretation and constitutional interpretation are not suitable for AJS. You see, when we are dealing with family issues, custody of children, maintenance of children, we are dealing with basic issues. Who among these two parents should have the custody of children? Among them, and among where they live, they actually know who can be able to provide the best interest of the child or be able to be the best parent for the child. You don't need any law to tell you the child will need to eat and go to school and pay school fees for them. When it comes to inheritance, the same. Who died? Is it the father or the mother? Who is entitled to inherit from that estate? What estate did this person who died leave behind? So, those are the basic things that are dealt with by AJS. I think if they are complicated legal and constitutional issues that have gone for determination by the Court of Appeal, I think those should be left for the Court of Appeal to determine. But basic issues of who died, what he left, who are the beneficiaries. The law also tells us, like in Kenya, how that estate should be distributed. The law says how it should be distributed if somebody had many wives, how you should distribute it between the wives and the children, or if it's one wife, between the wife and the children. The law is clear. There requires no interpretation, because even if you go to court, the court will tell you the section of the law that deals with the distribution of the estate. But if there are complex legal issues, I think going into paternity, and complex issues that we read about, modern parenthood, and, I think those may need to go to court for legal minds to apply themselves. And the NJS will refer that also to court for interpretation. I hope I've answered your question, Anne.
It's a resounding yes.
Yeah, thank you.
Is there any other question? There's one more question there. The final question to you, Madam CJ.
Thank you, the Chief Justice, Deputy Chief Justice, and all judges and justices present. My name is Milton Ochen. I'm also an advocate in private practice. My question, in line with the paper presented or the keynote address, is on the side of ADR. I'm drawing from my experience when mediation was rolled out in the commercial court under the leadership then. I believe Justice K was there. His Worship Arutu, and then now Justice Amy Vincent Mugabo. I was one of the mediators, and one of the challenges that kept repeating itself despite the success that was achieved was the fact that sometimes you see the invisible hand of the advocates in influencing the outcome of the mediation process, sometimes positively, sometimes negatively. As we are discussing this, and I agree this is the direction to be taken, we need to bring in ADR into the family justice and elsewhere. My understanding also is that by the time these cases go to court, there is an advocate somewhere, and I'm asking this question as a stakeholder in this process. Earlier on, my senior brother, Dr. Honoria, said lawyers just sit there, and we laughed about it a bit. I want to assume that we should not discount the role advocates play, especially to our clients, in influencing their decision-making processes in ADR and mediation in particular, where they are not so active and mediators are facilitating the process. My Lord the CJ, I would like to request that you share with us the Kenyan experience, how you've dealt with this issue of onboarding the lawyers, the advocates, into buying into this ADR, especially like mediation in the justice system. Thank you.
Wow, that's a very, very profound question, because indeed I can't agree more with Advocate Milton that the role of the lawyers is very, very critical. And they guard their tough. To begin with, here in Kenya, the lawyers thought that NDR, court annex mediation, AJS, have come to take away their work, so that parties do not have to go to instruct a lawyer, pay instruction fees and open a file, but instead they can go to an NJS panel and register their matter there. And therefore, we have had to work with the lawyers in this and make them understand that, in fact, one of the facilitators of AJS gave a very good example in a training I attended with the lawyers. That, look, we lawyers, we have so many cases in our chambers, a lot of backlog of cases which we haven't finished. Some of them going for years. But now we are opposing NJS and we have not finished even what we have in our chambers. And he gave an example of a mother with many children, serves food to them to eat. You have food in your plate, but before you have eaten, you're even looking at the serving pot where it is coming from, asking for more before you have eaten what you have. In other words, you challenge the lawyers, have you finished the backlog of cases in your chambers? Before you start thinking of these people who are going for AJS and NDR, and these are mainly the vulnerable, the families, you know, who really need expeditious disposal of the dispute. Because if somebody died and the family is left, the widow is left with the children, she doesn't know how to pay school fees or how to pay bills, and she has no money whatsoever, she can go here and she can be assisted on how to obtain letters of administration, and she can access the estate. Eventually, it turned out that they actually go for the lawyers. So what we have done is go for the lawyers because they are there, and that's their profession, and we must protect that profession as well. But assured the lawyers that this does not take it away from you. It expedites, because you will be able to deal with many more matters and close many more files this way. And by closing more files, you'll have more references, more people referring, more clients to you to come and open a file with you, because when they open a file with you, the matter is finalized within a short time. You've closed that file and you have moved on. So it is important. Like you have held this conference today. When I was speaking at first, I didn't know we have many lawyers, many advocates present, to move with the lawyers together, because the system must also be supported by the lawyers. They must see the gain in the sense that we will have a system of justice that is quick and expeditious, a system of justice where you don't get frustrated also keeping a file and keeping a client year in, year out. I was a practicing lawyer and I know how burdensome it is to keep a client forever, because with the advent of mobile phones, they call you throughout, they call you even at night. Now, if you're able to have a time frame, I will open this file and within 6 months I've closed it, then you can live also a good life as a lawyer without having to carry a big baggage, or people who are chasing you all over because of their file that has been opened for many years. So in terms of expeditious disposal of the matters, I would urge the lawyers to embrace AJS and also embrace court-annexed mediation as a medium of accessing justice for their clients. I hope I've answered you, Mr. Milton.
Yes, my lord. Thank you.
Thank you. Thank you, my lady CJ. My final questions to you before I hand over back to the Deputy Chief Justice is, you mentioned the Alternative Justice Steering Committee. Perhaps you could tell us what that mandate is, what their mandate is, and who sits in that committee. And the last question to you is, how has the judiciary of Kenya ensured that there is adequate resources to continue sustainably funding the ADR and AJS within the judiciary? Thank you very much.
Mm-hmm. Thank you, Barbara. The AJS is steered by the National Council on AJS Steering Committee that is chaired by a judge of the Court of Appeal, the Honorable Professor Joel Goge. And he has been the architect, the engine. He's very passionate about AJS. I sent him to Uganda when you had the Africa Regional Conference on NDL, and I think he made a presentation. The reason why His Lordship, the Deputy Chief Justice, came to see the model here. So it's a broad-based committee with actors from all the sectors. As you hear, we need advocates, so the Law Society is represented. The religious organizations are represented. The civil society organizations are presented. The judiciary is presented. The Office of the Director of Public Prosecutions is presented. The Attorney General is presented. So this kind of the steering committee at the national level is cascaded also at the court level, where we operate in form of the court users committee, because those are the same people you find at the court users committees. The Law Society, the Office of the Director of Public Prosecution, the Attorney General, the police, the local NGOs, the religious organizations. Our constitution also envisages involvement of the people when you are making critical decisions that affect them. We call it public participation. I don't think you have it in Uganda. It is the one that is giving the Kenya government sleepless nights, on whether any policy or any law has gone through public participation. So the steering committee gives it the buy-in because it's about the people. It's about consultation and listening to people and designing all the AJS models that we are operating according to the needs of the people. So the steering committee is the brain behind the learning of the AJS, and it is the connection between the AJS and the court. About resources, we get very little resource allocation as the judiciary, even to do the normal work, of delivery of justice. I'm actually ashamed to tell you, since AJS started, we have never had a line budget provision for AJS. And for this, I'm most grateful to Professor Joel Ngugi, because it has been purely funded by the partners. It is partners who have funded us to where we are. This year, we were expecting to get some budget line, but we are still having some complications here and there. So we are still relying on our development partners. IDLO has been one of those very faithful partners in supporting AJS. And we've really had tremendous support from our partners to support AJS. But now we have been able to include it within the mainstream judiciary for funding by the government when the fundings become available. Thank you.
Thank you. Thank you very much, Madam CJ. I hand over back to the chair of the session, the Deputy Chief Justice, to close us.
Thank you, moderator. Thank you, my lady, for sharing with us the Kenya experience. It is always lovely to hear from you. It's extremely useful, and we shall continue to learn from each other. I was actually in church yesterday morning, Sunday, and I was sharing with our church leaders that they should learn from the Nakuru Reconciliation Center. Remember, I was there when we were opening it, and the church leaders, I think, will take it up. So we shall continue sharing, and we are most grateful for this insightful disposition to the audience. So we clap now and say thank you very much.
Thank you. I receive. I receive. Thank you. Thank you.
That concludes this session.
Thank you. Bye.
Thank you, my Lord DCJ. We now return back to our session that Lady Justice Helen Obura was chairing. My Lord, you have the next 1 hour to finish up the 2 other presentations and a joint plenary. If members are tired, 1 minute of standing up, like Justice Chibita told us in the morning, if you wish to do that, I think it will do our backs good. May we, for just 1 minute, stretch a bit, otherwise we don't want family justice to go with our backs. We should instead go with stronger backs. Okay, we may sit down. Lady Justice Helen, over to you.
Thank you, Your Worship. May I request that we now sit down and embark on business. Within the short time that we have been given, we have another presentation that was originally supposed to last for 2 hours, but we now have to condense it within the 1 hour and also include the plenary. So I'll invite the presenters. The topic for the next presentation is joint discussion on the practicability of mediating family disputes, managing psychological and emotional challenges during mediation of family disputes. And the presenters are Professor Belle Blondell and Professor Andrew Hauha of Pepperdine Caruso School of Law. So, Andrew? Yeah, how many? 2, 3. Who is the third? There are 2. 2. Yeah? Oh, I'm sorry. The third, Pepperdine Caruso School of Law is also, there is also a presenter from there. So we have 3 presenters. We have 1 hour for both presentation and discussion. So I will allocate only 10 minutes to each presenter, and then we'll have the remaining 30 minutes to make our response. So I'll invite Professor Andrew to start.
Thank you, Lord Chair. My Lord DCJ, kindly allow me stand on the protocols laid by my sister, the Chief Registrar, in the morning. May I request the IT team to connect with the 2 presenters, Professor Zumenta, Zena, and Professor Blandel. Are you there? Yeah. Thank you, Professor Zumenta, Zena, and Professor Blandel. You are most welcome to this session. My Lord DCJ, you will allow me to introduce the Pepperdine professors that are coming in to moderate this session. My Lord DCJ, Professor Blandel is well known to you, and Professor Zena as well. These were your professors when you were pursuing your masters in dispute resolution for 18 months. Professor Blandel is a professor of law and director of the Strauss Institute of Dispute Resolution, and holds a doctorate of law from Washington University. At Pepperdine, she teaches mediation theory and practice, psychology of conflict management. She directs the Strauss Institute Mediation Clinic, ethical lawyering, leads the faculty for Women's Negotiation Academy, and also my Lord DCJ. As you know, she teaches mediating the litigated case. And this is what, my Lord DCJ, you are piloting at the Court of Appeal. My Lord DCJ, prior to Professor Blendell joining Pepperdine Community, she served as the manager of the Kings County Alternative Dispute Resolution Program in Seattle. She also coordinated the dispute resolution program at the Seattle District Court. She has done quite a lot of work, including teaching in a number of universities in the US, including the Seattle University School of Law, and also the University of Washington, teaching strategic negotiations. My Lord DCJ, that is Professor Blendell Stefan. I will now introduce Professor Zena Zumenta. Professor Zena holds a doctorate from the University of Michigan School of Law, and she's known, commonly referred to as an internationally known mediator and trainer of mediators since 1981. She has taught mediation, my Lord DCJ, at Pepperdine, and again, you recall she was your professor, and also she's taught mediation at Hamline University. Both of these two distinguished ladies, my Lord DCJ, have earned distinguished awards from all over the United States for the work they have done in the area of mediation, specifically family mediation. Lord Chair, I request that we put hands together to welcome the two distinguished professors. We shall be jointly facilitating this session with them. I'll now invite them to begin, and will chip in as and when the need arises. Professor Zena Zumenta, you now have the floor.
So I would like Professor Blondell, please, to begin.
Professor Bell.
Thank you. Thank you. I want to start out by thanking His Lordship, the Deputy Chief Justice Butera, for having us. We are so grateful for the invitation to speak at the Symposium on the Family Justice System. What an incredible 2 days you have pulled together to have high-level and meaningful conversations about the intersection of the family and mediation in your justice system. I'm quite impressed and blown away with the agenda. I'm also, may I just comment, that I have not seen the Supreme Court Conference Hall in Kampala before, and as I signed on this morning, what a beautiful space. We are virtually presenting some, so thank you. And while we are not neighbors like Kenya, we do feel like we are neighbors to Uganda, and so treasure the relationship and the partnership that we have forged over the last I will also have Professor Zumeta speak to her gratitude in just a moment. I will introduce kind of our roles. I am the generalist as a professor. My expertise is in what we call table skills. I run the mediation clinic and I have been in a clinical faculty. And what clinicians do is they take the theory and they help put it into practice. So I bring students out into the courts, and each week we mediate cases and we help the students take the theory and put it into practice. The focus you will see from me is a focus on the table skills, particularly the psychological and emotional table skills. Professor Zumeta has been mediating in the family law space for, as you heard, since 1981. She is the consummate expert. She is the subject matter expert in this particular area, and I'm so excited for you to be exposed to her expertise. This will be an opportunity to share. Family disputes differ from general civil disputes in many ways. I've noticed in teaching students that family law can sometimes be daunting. It can seem like the biggest conflicts that exist. This covenant we take with God to enter into the marriage relationship is one that is deeply personal. And it is also a covenant with our legal system. And that contradiction between the two different contexts can create dissonance. And many of my students feel a sense of despair when approaching a family law dispute, because the level of conflict, the fighting words that are used, the deep psychological barriers of impasse that prevent people from going from no to yes, all seem overwhelming. Professor Zumeta and I in our discussions want to impart some hope about the potential for the resolution of family law cases in dispute resolution. And in fact, this is an area that is quite successful. This is an area where you often see the resolution of disputes in the US. You often see high settlement rates. It doesn't mean that they look exactly the same way that your typical civil cases look. Instead, they have a different tone. They have a different flavor, and it is one that can be learned through excellent training. I received from my students in the master's program some outstanding papers. One of them was focused on the training of the pool of mediators. And it comprehensively talked about the importance of the stakeholders. The stakeholders being the family division of the High Court, the attorneys and advocates critical to success, the litigants, the government of Uganda, the civil society organizations, foreign nationals, advocacy organizations, women's rights organizations. There are all sorts of organizations that ultimately have the same goal in peace. And being able to clarify that, include the stakeholders at the table, is critical to the success of family law as well. Conflict cannot be avoided. Conflict in families and in society cannot be avoided. The potential where children are involved, is the potential to learn how to separate and or co-parent in a way that supports the resource of a country, which is the children. And that is the vision and the potential for a functional dissolution or divorce mediation program. I'm hoping that today, as we have our short time to engage with you, we both learn about ways to move forward this important dispute resolution mechanism in our society. Professor Zumeta, I'm wondering if you can respond generally, and then we will move on to some more specific issues.
Thank you, Professor Blondell, for that introduction, and thank you all for inviting us to be part of your amazing summit. And we feel like we have are sharing your home in presenting on this important topic. We are just so delighted to be able to do that. And Professor Blondell, you have indicated some of the important issues that come up in family mediation. And listening to the Chief Justice of Kenya, she has also brought up many of the issues, and with your questions that are so important. And what we would like to do, as Professor Blondell mentioned, is really to bring it down to the table and to what is it that happens at the table, and how do we, working with the attorneys, working with the parties, how do we actually begin to help them to resolve in the face of all of the high emotion and the community issues, as well as the legal issues and the judicial issues that we are presented with. So thank you so much for having us here to present. Professor Blondell, good.
Wonderful. So one of the things that we thought we might do in order to get the conversation started is to ask the family court to help us frame the issues. So I'm wondering if Justice Udis is present. Professor Hauha, you can help me with this. We were going to request that the head of the family court, Justice Udis, help us understand how currently he deals with the psychological and emotional challenges that arise at the table. What are the concerns? Professor Hauha, does that work in the room?
My Lord Justice Kaitrima, how do you deal with the psychological and emotional issues that arise at the family court?
Well, when matters are brought to our courts, it's usually about addressing the issues that are raised and then applying to the law to those issues. With regard to the psychological aspect, especially of the weaker groups that appear before us, it depends on the skill of each judicial officer. One, to detect that there is a problem, and two, to create an environment that will enable somebody to articulate their issues freely. Where these parties are represented, the lawyers will assist them to bring out the issues that they have brought before the court. When they are not represented, then the court has to see how to assist the party who is not represented to bring out the issues and to build confidence in them. We have had situations, and I talked about them this morning, where somebody is so overwhelmed to even testify. And it depends on the preamble you give out before the hearing starts and the assurances you give to this party to reassure them that they will be heard and that their grievances will be addressed. I have told people that it's not so uncommon for litigants to break down and start crying, or for litigants to come with an entitlement over something. And therefore, as a judicial officer, there is that challenge of how you bring about, how you first of all control these emotions and then build the confidence in the parties. It's a skill, I think, depends on each judicial officer. There's no common approach to this. Some of us will adjourn the cases if they cannot manage those emotions. But once you have that opportunity, you are able to know where the party is coming from and to try as much as possible to ensure or to assure them that their matters will be heard, and to tell them to remain calm for them to be assisted. It's a very difficult thing, especially if parties have come from a very long background of oppression, and for you think you are going to calm them within 5 or 10 minutes. But we try our level best to prepare them, to assure them that they will be protected, there will be no reprisals, and it's unless they tell us the story very calmly and candidly that we can assist them to resolve their dispute. That's when it's in a protracted litigation. Now, with the mediation, of course, the caucuses are very important. When you're talking to each party differently, separately, there even the environment is more calm, I believe. That you try as much as possible to appreciate where this person is coming from. You get situations where somebody says, my lord, I just want to get out of this thing and I don't even want to take anything out of it. They just want to get out of a relationship. Some of these disputes are so sentimental. I mean, like inheriting property from your father is not like any other property you've bought on the streets or in the village. So for somebody to take that away from you, you really bring out a fight of your life. And therefore, what should happen, especially in a mediation setting, is to cool down the tempers. Otherwise, before you know it, it is a back and forth from each party, shouting matches. And for us judicial officers who are used to giving orders, it takes a lot of patience, actually, to ensure that you set the ground for this discussion to go on normally. It's a skill we don't learn in the law school, but you develop over time. And I think if there is a need in training, that's an area I think we need as judicial officers. How do you manage emotions? Because family disputes are so emotional. We also have pretenders, by the way. At times, somebody will just uncontrollably cry and you think she's the victim in this. So how do you also appreciate that aspect? But that's not to say that that's what prevails, but yes, you have to really level the ground. You have to build the confidence amongst the parties. Most importantly, for them to tell their story, and also to craft an output that they think will be fair to them. Yeah.
Thank you, my lord. Professor Zina and Bell, anything you can respond to arising out of that?
Professor Zina, would you like to take it first? You want me to take it first? What's your choice?
Yes, I'm happy to. And I I so appreciate what Justice Udis has said. I think in many ways, it's not so different in mediation as it is in the court, in the sense that our job is the same, to help calm people, to help them feel like they are heard, to help them craft an outcome that feels fair to everyone. And of course, as you've mentioned, the stakes are so high, both in terms of people's identities and what they're attached to, as well as the emotional level within the relationship. We do have an advantage, as you mentioned, in mediation, in that we have the caucus and we can talk with people separately. I personally start out my mediations that way, talking to each party separately, so that I can get their story, so that they are able to connect and feel a little bit safer with the mediator. Sometimes it's helpful to have co-mediators of two genders, so that both parties feel really comfortable talking to the mediator. And there are times too that you might want to have a caucus with the family, but understanding that it is the parties in the end, the husband and wife, who really do need to come to that agreement and feel like they've been heard, like we understand what the issues are, that they understand the options, and that they can talk to each other. Whether we want them together in the same room is a very good question. Can they talk calmly? Can they actually communicate with each other? And we do sometimes bring the attorneys in for that reason, because the attorneys can often calm their parties down and allow the conversation to go on with everybody in the room, instead of just in the caucus and back and forth. And Professor Blondell, would you like to add to that?
I would. Thank you again, Justice, for framing the issues so beautifully. I'm clinging to one of your very wise statements. We did not learn this in law school, and we did not. I do teach psychology of conflict communication, and not many of my students, the students in the law school, actually take the class, but I do think it's of so much value, since litigation is about conflict, to learn how to communicate through it. Some of the skill sets that are taught include classic de-escalation skills, the type of skills that you might teach law enforcement, the type of skills that you might actually be using in diplomacy. Those are the same types of skills. And as you were so right, I love how you said the fight of your life, right? So we study a lot about the fight response, the flight response, the freeze response, and the fawn response, and how each of those are typical physiologic reactions to conflict. They show up differently with different people, within communities differently, within genders differently, within cultures differently. And I know Uganda is so rich in cultural diversity. And learning how to be responsive to each of those typical displays of emotionality is critical to the job description of the mediator in this particular type of mediation. What I found is that my students over time start to enjoy these cases where before they were plagued, because the skill sets are learned and you can see the results of the application of the skills. I'll pause there. I could go on for too long, I'm sure, for all of you at the end of your day, but I'll pause there because I know we had more planned, and I'll ask Professor how he'd like us to proceed.
Any question from the audience? The family mediators, Mrs. Shonobi, any question to the professors?
Thank you, professors. I picked up a few words that I may have never used or may not have used in quite the way you've used them. Like, we help them craft an outcome. That's something that I'm going to deliberately do in my next session. Because sometimes the self-determination allows you to let them do it, but then if I'm consciously now sort of veering towards getting them to craft their own solution, I think I'll be faster in getting them to or break an impasse or even just understand what they really want. So I like that word, and I've written it down. Thank you.
May I comment on that?
Yes, please.
In particular. So how we would describe that in the theory is there's a grand contradiction in family law mediation, because in some ways it is very directive. For those of you that have been exposed to the styles of mediation, we have directive and facilitative. Directive would be a little more mediator driven, though the self-determination of the parties, as you wisely reference, is everything. But the process might be more mediator driven. Facilitative, the process would be driven by the parties. Family law is uniquely a contradiction. And the reason I see it as a contradiction is because there's one statute or a small suite of statutes, different than much of civil law, where there might be many both common law or civil law principles that are informing the outcome. There is more predictability, at least in the US, around family law. And for this reasons, the mediators are a bit more subject matter experts, which means if you're a subject matter expert, you are bringing more structure to the table. Now, you've got to do that directive mediation style dealing with families who are hurting. So it has a real facilitative tone at the same time. So for the mediators, they are in a directive context, but needing to deal with the emotions and the needs and self-determination of the parties. And it requires using two different styles of mediation at the same time. And that's one of the hallmarks of a good family law mediator, is understanding that they have different roles and that they seamlessly wed these two styles together in order to serve the parties. Professor Zumeta, would you like to comment? You may see it similarly, or you may have a different take on this. She is the expert.
So I think you are so wise, attorney, to really notice that in helping to craft an agreement, we are the helpers. We are not telling people what to do. We can't do that, and we don't want to. And yet the parties come in first with those emotions, but also not really understanding what the law would give them. So it's helpful if the attorneys, if their own attorneys, have talked to them about the parameters of outcomes and what the court would be likely to do with their situation, so that when they come into us, we can talk about their options in terms of what might happen in court, but also what they can do beyond what would happen in court, and to help focus them on what some options are can be very helpful, so that they're not needing to come up with all of the ideas themselves. They may not be able to. But we also don't want to tell them what to do. We're really trying to help them understand the options and then begin to focus in on which ones might be workable in their situations. Now, having said that, I would also say that many parties do come up with outcomes that I would never have thought of because their situations are unique, and they may find that there are possibilities within either their separate or joint communities or their abilities to work with their families that we wouldn't necessarily have even thought of, much less suggested. Although over time, I have to say I've begun to understand some of those options myself to be able to present them. So Professor Blondell, anything you want to add to that?
Professor Zumeta, could you give us an example? It may not be one that culturally translates, but could you give us an example of a moment in a mediation where you were surprised by a solution someone presented? I can as well, if not, but.
Well, I'm thinking, of a particular situation where my assumption would have been that the wife and perhaps the children would have moved out of a particular home that was given to them by the husband's parents. But in that case, the husband's parents were so close to the children that they wanted the husband to move out rather than the wife and the children to move out. And the wife was perfectly happy to do that. And that was different from my expectation of what would have happened. In that particular situation, it made sense. And I should say that the husband's parents also did find a home for the husband. They weren't kicking him out of a home completely, but those were options I would not have expected and wasn't aware of.
Thank you. Dr. Tim, you had a question?
Yes, please. Thank you, Professor Kauka. I'm asking, first of all, to thank the professors for their good presentation. And then my question is to, I think, Professor Blondell. She mentioned that students participate in the mediation process at court and mediate cases and so on. So I'm just hoping she can elucidate more on how that framework works. Is it a court policy that there will be student mediations facilitated by students and then they enter arrangements with the university, or what? Thank you very much. And are the students accredited for that role that they play? What does it mean for their regular curriculum at the university? Thanks.
Thank you for that question. The training ground for mediators is often small claims, what we call unlawful detainer, or civil harassment. I'll go back to those 3 calendars. Those 3 calendars are calendars that sometimes the parties show up unrepresented. So there is a need to have courthouse mediators help the litigants have the conversation. The class that I teach is a 2-unit class. The students do get credit, and they show up at LA Superior Court every morning, available to mediate those cases. Those cases do tend to go forward. The calendar is so robust, and there is so much time you have to wait to get onto the calendar, that what you see is, you either prepare and present and go in front of the judge that day, or else you're not going to get another court date. So there is an incentive for people to go ahead and try the mediation process. There is not much delay. Teaching law students to practice the skills is also a challenge. One example of dealing with the psychological issues is I challenge my students to make a statement of empathy in each mediation. Now, I know that may sound like a small task, but it's actually a big task. I even give them a template for the languaging. So, something along the lines of most people in your situation who have a dispute with their landlord about the deposit are feeling angry, frustrated, or tired. Is it one of those? So you normalize the situation. You're referring to your own expertise, having mediated many of these cases, and giving people the permission to talk about the emotional landscape. It is my experience that this does not open up the floodgates. It doesn't open it up, and then we're doing that for the next 15 to 20 minutes. My experience is a simple statement of that empathy can be enough to allow people to move psychologically. I always say that my job is being an expert and helping people go from no to yes. Really, as a mediator, we are experts in decision making, helping people go from no to yes. And the expression simply of a psychological experience they're having, an emotion to someone they see in authority. Because even though the mediator is not the authority, the parties are ultimately the authority, they see the courthouse mediator that way. And that simple release can be enough to move people from no to yes, not always. So we teach the students to make those types of empathy statements. The 3 calendars we do, and I'll just refer to that again, is small claims, that's under it's under $12,500 US dollars. Unlawful detainer is an eviction, basically the landlord-tenant court. And civil harassment, I think, is my favorite calendar and the most difficult, but the most interesting. It's when people are seeking a restraining order, but they are not actually a family. So it would be between people living together in an apartment building, or between coworkers, where there has been the level of conflict has risen right to the level of violence where someone thinks they need a protection order. And we are very successful with mediated agreements in that context as well. So that's the clinic, and it is an exciting container to teach the legal community of tomorrow how to resolve cases. Most lawyers leave law school knowing that they will most certainly sit in a mediation room. They may never walk in a courtroom, but they will most certainly be spending days in mediation. And it's the skill set that they need to be successful.
Thank you.
Thank you. I think, professors, our time is getting up. I will seek guidance from the chair of the session, my lord.
I think we need some time also to discuss the earlier presentations. So maybe I'll give them 5 minutes within which to wind up, and then we go to the plenary for the other previous presentations. Thank you.
For winding up, Professor Zena, do you think we should demonstrate? Could that be a way to wind up?
We just have one more. We just have one more question, my Lord Justice Henrietta. You have a question.
Thank you, Professor. I just want to thank the professors for drawing our attention to the responses, the typical responses from some of the parties during these mediation proceedings, that is flight, freeze, and fight. This reminds me of a case where I just set out to hear the parties, and then the lawyers said they wanted to see me. The caucus that Justice Ketrima has mentioned. These are terminologies I'm learning here. Now, the lawyer said, the issue after we had scheduled was that one of the administrators did not recognize one of the children. She was actually the paternal, the sister to the deceased, and then the respondents were the wives. She didn't recognize one of the kids. But the mother of this child actually agreed that that child did not belong to her late husband. So, it was an agreed fact. But she was still fighting. So now I recognize this, this response. she was fighting. So I asked her, children did not choose to be born. I didn't even ask, I just made a statement. Children did not choose to be born. In any case, your brother had accepted this child. So why are you still fighting? Then she said, okay, we're going back, and the next day they came back, with an agreement. So what I'm trying to say is sometimes if you appeal to normative standards, normative norms, bigger norms like that, when I said children did not choose to be born, and that is a fact, she was able to come down to the table and agree. Thank you.
Thank you, my lord. Perhaps Professor Zena and Bell, could you please throw some more light on flight, freeze, and fight? Try to unpack it a bit within the few minutes we have been given.
Certainly. Why don't I take the lead, and then Professor Zumeta, why don't you follow up? So fight, flight, freeze, and actually fawn is one that's being discussed much in the literature as of late. So fight would mean my back is up against the wall, my fight or flight response has been triggered, and therefore, I'm using fighting words, or I'm using fighting motions. Flight is I'm going to run away. So I'm going to try and just give you everything in order to get out of it, as was referenced in the very beginning by I think it was the Deputy Chief Justice. Freeze, I'm not able to do anything. I'm not able to bring the documents. I'm not able to show up to the hearings. I'm avoiding. These are all typical responses. Fawn is I'm trying to make things better. So fawn might be what someone is doing when they're in stress, when they're in trauma, but they haven't decided to leave yet. They might be doing fawn, trying to hold everything together, right? So fight, flight, freeze, fawn. They are physiologic responses that we have not evolved out of. We are just like the mountain lion on the savannah. So when I'm making this up, this is something you may know more about than me, but when the lion comes, I'm going to imagine it's a lion. You're either going to run. Will you outrun let's call it a mountain lion? Will the rabbit unrun the mountain lion? Maybe, maybe not. So when they can't run, are they going to turn around and fight? Probably not, right? So that's where these two other responses that we don't recognize as much as conflict responses come in. One, freeze. I'm going to play dead. Maybe they won't notice me. Maybe fresh meat is more appealing, right? So it's a physiologic response. Or appease is the human manifestation of that physiologic response. It's okay, it's okay, right? So we take those responses, and the sociologists will study the table skills for each of those responses, but they are very much from our sympathetic nervous system, what human beings and all animals do when their back is up against a wall or they are in conflict. And as lawyers, there's a culture that we need to adapt. We need to recognize this, what is happening to us. For whatever reason, God has given us this container in which we have feelings. It's a fascinating, I think of it as a fascinating concept that human beings were given emotions. We're a bundle of nerves that make emotions. And since we've been given those emotions, and it's something we all share, studies show in neurocollaboration that people are not able to overcome those feelings with reason. Usually, the feelings are dictating our reason. That's a longer argument that I would talk about it another day. But because of that, we need to learn the table skills, and lawyers, there's a culture for how we address each of those feelings. We need to use the culture of legalese, the formality that goes along with incorporating emotion into advocacy. because we can't just pander to, someone who's crying and crying and crying. Instead, we bring forward skills at the table that will allow for it and help move people on to the next step. So that's the fight, flight, freeze, fawn response. Professor Zumeta, what would you like to add in terms of?
Just that one of the things that we do learn or teach mediators is when you see people in those states at the table, what kinds of things can you say that might be helpful? And the justice was so brilliant in talking about children don't ask to be born, because that is a wonderful statement that allows an emotional person to take a step back and from their own emotions and actually look at it a little bit more objectively. So a brilliant table skill right there.
Thank you, Professor Bell. Thank you, Professor Zumeta. This brings us to the end of this session. I now hand back to the session chair.
Thank you so much. I request us to appreciate them by clapping. And they have given us a different perspective from their experience, and I believe we have learned something that we can apply in our own courts. So thank you so much. Thank you.
Thank you.
Thank you so much.
I seek leave from the program manager to extend this
20
session.
minutes, my lord.
Yes, I appreciate that, because as you are aware, our time has been eaten up into by many things, but and yet the topics that we covered earlier were equally important, and I don't see one of the presenters. I hope Dr. Honoria is still around with his team. They have left. Oh, how unfortunate. And yet I wanted to put something to him that he could make a rejoinder on. Her worship is around.
Yes,
Please,
my lord.
please step forward here, and you receive the questions that will be presented. And could I have the Administrator General as well? And we receive questions and comments, observations as they come. One of the findings of the research was that there were fewer cases registered at the Administrator General's Department on concerning estates of women. And it was the comment of Dr. Honoria that there are less women who have control over property. I wanted to submit that in addition to that, perhaps it has something to do with the lifestyle of women. Very rarely do you see men appearing at the burial of women with children and alleging that I had this child with this woman. But I think it's a common feature at the burials of men. So, and then also the other thing is that the relatives of women and then the children don't usually give trouble to the men, the widowers. But the widows have to deal with all kinds of people who have interest in the estate of men. So I wish to now open up the discussion. If you have any question, yes. Let me start with Dr. Patricia Tim.
Yes, thank you very much, my lord.
Kindly indicate who you are addressing your comment to, or question, or observation.
Yes, please, to the Administrator General. Can you kindly elucidate more on the status of the wills depository that we are supposed to have as a state provided for under Section 333 of the Succession Act, to ease, somebody called me from Netherlands and wanted to write his will because he has property in Uganda and submit it in Uganda for custody, something like that. So I'd like to know that. And then 2, I'm wondering at the Administrator General's office how you're handling couples in cohabitation where the couples die, a partner dies intestate. How is the Administrator General dealing with those cases? Thank you very much.
Thank you. We'll take about 5 questions, then I'll ask them to respond. Please.
Thank you very much, my Lord Chair. My question goes to Her Worship Prosi, and I'm inquiring if there are any statistics that come from a survey from the people who have concluded mediations. Is there any feedback that we get? Someone has done a mediation, they have taken what they have taken, but is there any follow-up or any feedback we get from them if actually they got justice? Because there is having statistics that show that mediations have happened and that cases have been solved, but is there a satisfaction? I draw this from when you look at say plea bargaining, for example, there is people who are willing to take sentences for crimes that they have not committed. Why? Because it's been proposed to them in some cases, that it is easier on you. The trial may not be forthcoming, they may not be on the list of any sessions that is coming up, so they are forced to take them now. That might look like a case settled, but was justice delivered? So are there any statistics that relate to that satisfaction? Is mediation actually satisfying and giving the justice? Do people get anything closer to what they had pleaded for in the pleadings? Or do they just say, you know what, I don't want to waste any more time, I am tired, I'm better off doing other things, I just want to walk away? Thank you.
Okay, thank you. Any other comments?
There was a question at the back. Her Worship Ayebare Daffin, so your hand up.
Okay, please go ahead.
Thank you very much, my Lord. My concern is relating to Section 44 of the amended Succession Act that majorly refers to guardianship of children when both parents have died and there is no appointed guardian in the will. And Section 44 refers to statutory guardians, and then 44A refers to the customary guardian being appointed by the family. Now, my concern is there is a whole process that has to be we have to go through before a guardian is appointed, and the process of appointment of administrators. Are there measures in the interim that cater for the welfare of children? Because many a times we see that the children are left in the balance and they hang in the balance pending the determination of the question of guardianship vis-a-vis their overriding principle of the welfare of children. Thank you very much.
Thank you. I see a hand behind there, but I can't see the
My
face.
Lord, there
Please.
is His Worship Mfaizo Mulalira.
Okay. Please go ahead.
Thank you so much, my Lord Chair. I would like to ask both the Administrator General and Her Worship. There is a growing number of in the public, and this question confronts us when we go for sensitization and awareness, where they are faced with comorbidities. Maybe they are suffering from a stroke or other related diseases. You cannot bring them under the Mental Treatment Act to appoint managers for their estates because they are not mentally challenged. Neither can you bring them under the Children Act because they are not children. And their estates are always running in abeyance and creating a lot of havoc and property-related disputes. How is the Office of the Administrator General and how is the Family Division dealing with such cases? Thank you so much, my Lord.
There was another hand that side, please.
Yes, good afternoon, Madam Chair, and thank you. My name is Joshua Wemazima. I'm a practicing lawyer. My question is to the Administrator General. Since we are dealing with mediation, Sir Administrator General, there was a communication from the Attorney General saying that you did not have power and mandate to handle files under the succession register. Is it now the right time, if parties can mediate between themselves and come to a consensus, that you can now accommodate? I personally, we do have a file where UNRA is willing to pay and compensate, but the file is under the succession register and it can't move any further. Is this the time that you give us that latitude? Thank you.
Could we have Dr. Diana from the School of Law, Makerere?
Thank you very much, my Lord. I have two brief questions. In the statistics that Her Worship Katushabe presented regarding the number of administrators, the common number of administrators, the ranges were from 2 to 8. I wanted to know the prevalence of single administrators, whether it is a common practice and whether there are some disadvantages or advantages that come from that. Then finally, we appreciate the judiciary and the organizers for bringing the School of Law on board. We are doing some little work as we go through the process of mediation. So today I was listening to all the presentation and I realized, so I have a file, that I am handling, and there is all this distribution of property without, the main thing is that there's never been an administrator appointed in the whole process, but the parties are disputing. Basically, they're dealing with, I think that is what intermediating is. They're dealing with the property. There's never an administrator that has been appointed, and this is a matter where the day 3 relates to more than 10 years ago. Is that a case you would advise that we continue mediation? Is that a case that maybe you would advise that also the Administrator General gets interested if you're dealing with a matter and you feel that a critical stage maybe was missed, but people are going ahead to really argue about legality of the estate, who is taking what, when the first process of attaining letters of administration has never been taken? What advice would you give? Thank you very much.
Thank you. I'll request the presenters to first respond, then we'll have another round of questions.
Thank you, Chair. When you read section 3.4, talks about that the custody of wills, and the Attorney General is supposed to give an input in terms of prescribing fees. But this is a new law. Actually, there is also another provision on arbitration, where when a dispute arises between administrators, the judge can refer that matter to the registrar for arbitration. We are going to finalize this with the head of the family division. Maybe we engage first parliamentary council so that the Chief Justice can issue an instrument on how that arbitration can be done. But on 3.3.4, we are also going to engage the Attorney General. But at the moment, there is no ban that you can't keep your will anywhere, be it with Administrator General, Registrar of Court, your friends, the bank, which charges you some fees. This was also intended to act like the bank, that when you are depositing or making code seals, people also don't make code seals, or withdrawing the will, you will be required to pay certain fees upon instrument by the Attorney General. Cohabiting, yes. I was accused by my sister here that the Administrator General uses the word a friend to the deceased to administer an estate. It's not the Administrator General. Section 5 of the Administrator General's Act provides that a friend to the deceased can administer an estate of the deceased person. Now, if you are a girlfriend or you have been cohabiting with the deceased for 40 years, who refused to go and marry you legally. He has left you with 4 children, you have custody, you are gainfully employed, and you are taking your children to school. Why would the Administrator General want to impose an uncle who may come with new terms against this girlfriend? So the office has been exercising that mandate of a cohabiting person for a very long time, who definitely is a friend to the deceased, by issuing them a certificate of no objection. However, I have not issued that no objection to the male, because you had the right to go and marry this person, you kept her, and there is a possibility that you may correct NSSF and marry a second one. We can discuss it. We can discuss this. And again, the law now has entrenched, the Succession Act has entrenched this girlfriend. It is saying, for you to take the responsibility of this minor, you must become a legal guardian. And all the mandate and the responsibility and caring responsibility of that minor will be vested in you. And even when there is a disposition of property, disposal, you are required to give a consent. So this person you call a friend is now much protected in the law when she becomes a legal guardian to the minors, and therefore she can ably administer an estate. I will wait for your guidance on these boys, whether we can trust them with the estate, if they are not going to be supplied the estate of minors. Because I have some few examples where we tried and money would be accessed and shared with the other new entrants. I'm speaking from experience, not from friction. And there's no friction here. I will be guided. So, my sister, your worship, a friend to the deceased, is in that category, not any other. She talked about statutory, these customary guardianships. These are provided in the Act, but they are not legal. You can't receive property or register on the title if you have not obtained a court order for legal guardianship. Therefore, when a person dies, there is usually in the African settings who is next if the parents are deceased. That's why the law is talking about a customary guardian. They look at who is the next, who is in charge, who has custody. In the interim, even the Administrator General can come in as a public trustee to look at the affairs of that minor. Now, the person who has got stroke, unless it is proved that his mental capacity, the law now is no longer the Person of Unsound Minds Act, it was changed to Mental Illness Act. Unless he can fall in that category, or the category of death, or the category of missing person, we can't come in, because his head is still what? Functioning. He can give instructions, he can give powers of attorney, but we can't come in to manage his affairs. His affairs can only be managed under the 3 categories of a missing person, death, or mental illness. Of course, there is what they call dementia or something. It is also common these days. That one can fall under Mental Illness Act. If the person is incapable of understanding his affairs, the manager can be appointed. The issue of succession registers, of course, the There was a committee appointed, chaired by High Court judge with 2 other judges, and with the representatives from the Attorney General, the Administrator General, Uganda government, and all stakeholders. It established that the estates of Uganda, and this also applies elsewhere, as I was explaining in the morning, that were fully administered, and therefore letters of administration, which began in 72, cannot go to the estates that were administered in 1910, in 1914. Yes, on Friday I received an application of an estate of Chugula or something, who died in 1736. And the great 5th or 6th generation wanted a no objection from 1736, that they want to apply letters of administration that started in 72 under decree number 22. So the position of the law is that these estates were administered. The owners are aware. There are quite a number of principles of land law, including advance possession. And if you are occupying your land, it is your land. So going to bring the Succession Act of 72 that started to apply to us, the natives, when there were other laws that were applying, and applying them retrospectively is irregular and illegal. So therefore, the Attorney General also gave his opinion and communicated to the judiciary the findings of that committee. And there are many decisions. Paul Kawesa says the Administrator General is functus official because those estates were administered. So if the UNRA is passing in that road, you know which people are occupying that property. Let them be verified and compensated for that property. You can obtain a court order. The other people can really give evidence that indeed this asset or land is for so and so, and let him be paid. And the court order can be obtained, and the UNRA processes that part of the road. Of course, I have also seen mediation. I'm happy that you have raised it, because there was a confusion, first of all, when the Office of Administrator General and the Lands Office, among themselves, the two, decided that the succession certificates can no longer be issued in 2000, and they started now giving certificates of no objection and letters of administration to an estate like Sir Apollo Kagwa, who died in 1927, left 100 square miles, and then you give letters of administration to the 5th generation. So letters were being issued. So now there are some people where you find that there is a small residue, because now they can't be issued. You find that there is a small residue of 10 acres. There was administration under the 1912 succession law. People got letters again and distributed. So people can come in under mediation in that arrangement and say so and so got under the 1912 succession law. However, when we also got letters of administration, we gave so and so. So the remaining residue is for so and so. Under mediation, the court, I don't want that would be the mandate of court to consider a consequential order or a vesting order for any residue. Thank you.
I'll invite Her Worship to quickly respond, because I still have 2 questions that were brought earlier, 2 people who had already indicated their desire to raise some questions. So please,
thank you,
conclude, and I invite them.
Yes, one of the questions that was addressed to me was whether we get feedback from the mediation that is being carried out on the cases that are resolved. Yes, there is feedback. And as earlier they said, the feedback is actually now categorized, because feedback of a concluded case, feedback of a partially concluded case, and then feedback of where cases have not been concluded. And also, needless to say that when a mediation is successful, the file is taken to the judge to actually give the orders resulting from that mediation. So there is feedback on the mediation, if I may say that. And the other question was about the findings of 2 applicants to 8. What I may say is that because of the dynamics of how the family has been changing in Uganda, people were moving away from a single administrator, and now mostly because of fraud and because of the administrators taking the letters, and they turned the property to be their personal property. But this research was done in 2021 and 2022, just immediately when the amendment had come into place. So with the coming into place of the amendment, the powers of the administrators or executors have been greatly reduced, whereby they cannot do something without consulting the beneficiaries. But as of the research, I would still say that having a single administrator made it easier to administer the estate than when you had several, bearing in mind that now when you get letters almost in every office you go to, they require those people to appear. If you're 8, you all have to go to the bank to file. You all have to go wherever you are, making it difficult for where the administrators were many to administer the estate. And the last question, it was about when you miss a crucial stage, and I think the Administrator General answered it. Thank you.
I am sorry, I've been advised that we should stop here, so I'm unable to allow the 2 questions that I thought we would have. But as the CR goes to the podium, the Administrator General has requested for 1 minute within which to comment on the research findings or report. Yes, you're welcome.
Thank you, my Lord Chair. Of course, we have not had much opportunity to interrogate the research findings, but my comment on letters of administration, the very able team at the family division will also explore it further, but the nature of dispute did not come out clear about when people get letters of administration. Are these cases at the level of a grant that they are contesting the issuance of letters of administration, or it is post-grant, or partly at that level, or post? Because in our new Amendment Act, the law tried to address most of the issues which people were fighting on, which include disposal of properties by administrators without the knowledge of the beneficiaries. Perpetual administration, including Administrator General, 30 years, 20 years, but now the law is 2 years. Then they would apply for revocation. Then waste of the estate generally by the administrators. Then people taking long to get letters of administration. So I think the head of the family division and the judges at the division will take a further study to know the nature of disputes, because I estimate the contestation at the level of grant could be like 15 or 10%, but most of the issues are post grant of letters of administration. So we shall further work together and study the effect of 2 years administration, because now the administrators actually have been rendered powerless. I thank you.
Thank you so much. I'll once again request you to clap in appreciation to the presenters. And I want to thank you for your active participation. God bless you.
Thank you, my Lord, the Honorable Lady Justice Helen Obura, for steering this session. Let us give her a round of applause. Thank you so much, my Lord. a very, very interesting and good day we have had, my Lord DCJ. Thank you for steering us since morning up to now. I believe the conversation cannot end, but will continue. So we have come to the end of day one. Tomorrow we resume English time. We have done extremely well, by the way. This extra 20 minutes, even in football, they give extra time. So I believe this extra 20 has not been bad at all. Tea is available before we go home. We can continue chatting there. 8:30 tomorrow we are here. At exactly 9 we will be starting. And our session chair is the Honorable, the Deputy Chief Justice. So let's keep time. Thank you, and Janimas is home. Tea in all the 2 rooms, they're available. You may wish to network in level 6 this evening or to network at level 7. The choice is yours. Thank you.
Thank you.